the blue state what I'm saying. This whole analysis on page 9 talks about how the determination of a violation of the confrontation clause is subject to a harmless error analysis. And then the court went into the harmless error analysis and determined.
I'm sorry I'm cutting you off.
It's fine.
But,
it's just,
for me, I'm not going to start at the standpoint of looking at it as harmless error. It's error whether it's harmless or not. And in fact, what is harmless in one case may not be harmless in another. And when you get into confrontation, it's harmless error analysis. I can't remember reading a case where they ruled that a confrontation violation was a harmless analysis.
Sure. I will just let the court read it. The facts of this case are significantly different than the facts here. I still don't know what this is in relation to as what the state's attempting to introduce. So I'll let the court read it, and then the state can inform us what statements it's looking to introduce, and then we can have a discussion on the issue.
I'm assuming, and perhaps I oughtn't do that, especially in my job, that you're offering this with respect to the statement attributed to Mr. Gutierrez about the entry into his truck.
Yes, and who did that? Correct.
Right.
Yes. Yeah. Obviously, it's focused on what we last were discussing that the court has indicated is hearsay.
Let me take a look.
Please. Well, Judge, so my argument to the court is that under 908.045 sub 2, first of all, the declarant must be unavailable. In this case, the declarant is not available in any way, shape, or form, and the allegation here is homicide. And then it's a statement of a recent perception. The court has had a chance to read the analysis. The Weed case is essentially a wife who, in her appellate hearing, indicates that the circumstances of her firing shots and ending the life of her husband is that she essentially did not mean to fire at him, simply meant to scare him, essentially tried to eliminate the direct intent element from the allegations. The prosecution during the trial sought to admit and was allowed to admit a statement from that was from the unavailable party, the party who died of gunshot wounds, where he indicated that he had unloaded the pistol. So obviously the allegation is she had to have reloaded the pistol, bolstering an intent element in the trial. That indication of that where that was told to close friends. It was not told to law enforcement. It was told to close friends on a social occasion. It was told not in relation to any questioning or in relation to any specific queries of individuals. It was simply exclaimed as something that had occurred. And it was relating something that the court, the Supreme Court, state Supreme Court, was able to piece together had occurred 8 days earlier. What both Michael Campbell and his girlfriend at the time, Erica Saylor, are available to say is that we were at having either a meal or a social discussion with the declarant. The declarant told us, not in response to us questioning, that he told us both that he was dating an individual named Sadie, that she had a boyfriend, that his perception was crazy and was jealous, that the facts that he described to them were that the person appeared to have gone through his truck when he was sleeping over at Sadie's home, that the person had caused his own daughter to look inside the window while he had been at Sadie's home and was there late in the evening, and that he was aware that the individual had ordered trackers and was tracking and may be tracking the parties based on having ordered trackers, and that he thought the guy was tracking him. Those are the facts that they are aware of. Again, they are closer in time than the 8 days that the Weed case talks about. They are identical circumstances in that they are told to social companions and not uttered in any way as something that is for retribution to other parties. They will actually say that they were more concerned than Rosalio Gutierrez was, that he was not expressing any real concern, and that both of them said, hey, this is something you should be worried about, and that he essentially dismissed their concerns. So, it's the exact opposite of something that's testimonial. It does provide them sufficient information to, when they discover him missing, within a few days after those remarks have been heard. And so literally if they heard those during the week, that would be May 13th, May 14th, May 15th, we're literally talking about, within a couple of days, 3-4 days before he goes missing, that these remarks are made to them. When they, now remember, he's not discovered missing for 2 more days. When he is discovered missing on the 19th, they immediately, based on the conversations they've had with him, are immediately focusing their concern on the individual who Rosalio himself had brought up to them. They had not been provided a name of the individual. They knew Sadie only by a first name. They had never met Sadie. So I believe it's basically identically situated to the Weed case, and I disagree with counsel's brief characterization to the court. The Weed case clearly finds, the state Supreme Court clearly concludes that the trial court acted properly in admitting this evidence under that hearsay exception. They go on to have several paragraphs of analysis as to why that is a correct or a permissible decision. They then do the alternative analysis that I know the court is well aware of from appellate courts, where they say, well, even if we were wrong on such a case, there is harmless error. But they only do that at the very end, and they do not declare that, the paragraphs previous have indicated that it is a vigorous exception with the discussion that they have there. Now, again, if it's not testimonial, it does not require any additional indicia of reliability other than what the court needs required by statute, right? So the statute requires a statement not in response to the instigation of a person engaged in investigating, litigating, or settling a claim. So clearly that's not what I purported, which narrates, describes, or explains an event or condition recently perceived by the declarant. Again, he's talking about...
Let me interrupt you.
Go.
That was one of the concerns. No, you don't have to apologize. I just, as you were reciting the historic basis according to what is claimed, I didn't catch that Mr. Gutierrez had perceived what was contained in the remark. He made the accusation, but I didn't hear you say he saw it or otherwise perceived it with his own senses.
So that I don't think that's a requirement of the case, but let me answer that.
A recent perception.
Well, but it includes, Judge, it includes explaining an event or condition recently perceived. So so it does perceived can be concluded based on a series of facts. Perceived does not mean to be an eyewitness to. But what he will say is, I am an eyewitness to the fact that items.
No, sensory witness. You say eyewitness. I changed it to sensory witness. He has to have perceived it from his own senses, rather than just relate something that he heard from somebody else.
Okay, so I might not be quite catching, because obviously one of the senses is hearing. So are you indicating you must hear it? You must hear the actual thing personally, as opposed to hearing it reported by another?
You must have perceived it with your own senses.
Okay, so what occurs is he's located at these are the things he's reporting essentially. I'm located at Sadie's home. I am spending the night. While I'm located there, my car is interfered with. I know this because the items in my car have been disturbed. Okay. I then also I know that that Sadie expresses to me that that after the fact on that, I'm aware that the daughter, who I have not met, so the daughter was also a person who gazed in the window and looked at that time. Now, one of the things that Sadie has indicated is that there was a doorbell that was rung at her house as well, and Olivia also says that. I don't know if I haven't heard from Michael Campbell or from Erica Saylor that he reported that detail, that a doorbell was also rung in the middle of the night. But he certainly has expressed to them, here's who is messing with myself and with Sadie.
Here's who I think. And he may be absolutely right.
Right.
But the question is, what is the source of his knowledge? You're not just offering hearsay, you're offering what may be hearsay within hearsay. And I skipped over the first step, which is an unavailable declarant. I don't know that. I'm not suggesting that I couldn't conclude or the jury couldn't conclude that Mr. Gutierrez is unavailable from that he's deceased, but that's a prerequisite to the admission of this evidence, is that you show that this person is not available. And I don't know, it may be his mere absence after you've made efforts to obtain his appearance. That may be enough. I don't know the answer to that, but that is this threshold requirement. And then we get into perception. And now, having interrupted you, I'm going to give you the floor back.
Well, I mean, apologize, Judge. I assumed that based on the nature of the charge and what the court has heard so far in the record of all the individuals who have regularly been in touch, the amount of blood that the court was able to see during the course of this case, the fact that Rosalio Gutierrez has not been available to any of the people who had previously been really important in everyday parts of his life, that the court certainly would be able to conclude the unavailability piece. So if the court wishes me to make more argument on that, I can. But in this situation, Judge, he is commenting essentially on a perception that the declarant has where he is describing a condition. So what this says is so here's what it describes again in terms of the language. Or explains an event or condition recently perceived by the declarant. Okay, so there is a condition going on. The condition is that I am a person who is currently being victimized by a jealous ex-boyfriend of Sadie. That is his perception. Right. That's what it says. It says it explains a condition recently perceived by him. His condition.
That's where we're arguing.
Right.
I say perceive means something that the information one receives through his or her own senses, and you're on a different. You're using as a synonymous term, or I'm sorry. You're calling what I would call a conclusion, what he concluded from what intake sources he had, which would include its perceptions, but might also include hearsay information that he had received, or just pure, I want to say guessing. I mean, there's things that have happened in my life and in yours that if you ask me in a private conversation, did so-and-so do this? And I'd say, you're darn tootin' he did. But I don't know that. But I'm convinced of it. Well, go ahead.
Yeah, all of that can be explored by cross-examination, and obviously, in the end, no one is purporting in this case that Rosalio Gutierrez is a eyewitness to the defendant doing any of these acts. Okay, he does not see the individual. We make our proof in this case through phone evidence, through some defendant admissions when he is interviewed by law enforcement. None of those things does Rosalio Gutierrez personally witness. There will never be a time where a jury would, unfairly conclude, there's additional evidence that Rosalio Gutierrez is a witness to these items. It only goes to his what he expresses to his close friends, and it informs why they then do things that defense has said are interfering with this investigation and thus are shady, right? So the argument we have right now is that two guys jump in a car and gee, that it's really shady that they do that. They show up at the scene. It's really shady they do that. And the answer to that is we went to one person's house because we had some information shared with us just a few days earlier.
But you know, my job is not to admit the evidence that services your theory of the case.
Understood. So, but what I'm saying is it's not for the truth, it's not independently for the truth of it, right? Because none of what I just said, obviously if Rosalio Gutierrez tells them at a dinner, hey, you know, here's what I perceive as happening to me, and so it motivates them to do X, Y, and Z. That doesn't mean it's independently true, and it's very clear from the evidence that Rosalio Gutierrez is not an eyewitness to those things. He's never seen, in fact, as far as I know, these two have never seen each other until the 17th when this happens, except the defendant says the only time I ever saw him was when I peeked in the window, and saw him when I peeked in the window on the one date. So in his interview, so you know, this is evidence that a jury will be able to sift as not for the truth of the matter. No one can ever credibly make an argument that therefore it happened because Rosalio Gutierrez told people this when they were having dinner. But it is helpful to the jury to educate why people are not being creepy or knowing information. How would they know that unless something shady was happening?
I understand what you're saying, but the problem is that this particular piece of evidence is just pregnant with well, to prove the truth of the matter asserted. Yes, it's true. You're not directly offering it for that purpose because you can't. But
it wouldn't even be credible to do so.
Pardon me?
It wouldn't be credible to do so.
Well,
because
but even
he's not
if
an eyewitness. Okay.
but anyway, it's just pregnant with motive. To the extent if the jury accepts the conclusions. And by the way, I'm going to interrupt myself. Perceive has a broader definition than I stated. Well, at this is, I guess it's dictionary.com. And it says perceive as a verb, become aware or conscious of something, come to realize or understand, interpret or look on in a particular way. So that suggests that there may be a component of interpretation and conclusion included within the word perceive. So I guess that means that if we get further on this, we're going to have to go to the books and see what the rule was intended to capture.
Yeah, I thank the court for doing that extra look. That was my belief in terms of the definition as well, but I appreciate the court doing the extra research from the bench.
Well, had you finished?
So, I mean, the court is aware of what the definition of unavailable is. Do you want me to?
Well, that was the one I was unsure of myself on.
Okay. Did you want me to talk about that briefly then?
Let me get the defense's
okay.
response to what you've said so far, and that certainly will be an area that I'll have to be satisfied after hearing them, and if I decide that we're going to go forward. Go ahead.
The Court of Appeals in Kluver, that's Klueder, versus Evangelical Reformed Emmanuel's Congregation, it's 143, Wiz 2D 806, at page 814, talks about the underlying policy for the hearsay exception of statement of recent perception. This is a quote. This is a quote from a Court of Appeals case.
Did you say the year? I apologize.
1988.
Thank you.
The exception's purpose, therefore, is to admit probative evidence which in most cases could not be admitted under other exceptions due to the passage of time on the ground that no evidence might otherwise be available. And I think that's critical here because we're not looking at this statement that was allegedly made by Mr. Gutierrez as being the only evidence available to what that statement purports to be. This is triple hearsay. It's information, according to the state, that Olivia Anderson had provided to Sadie Beecham, that Sadie Beecham then provided to Mr. Gutierrez. Therefore, the state has two other witnesses that it can use to get this statement in. So it doesn't meet the underlying policy for this exception, that being that no other evidence is available. In the Weed case cited by the state, I think it's important to look at the facts of that case where the statement that was looking to be introduced was the decedent's statement of why he had unloaded the .357 revolver. And it was in a situation where the defendant in that case, after shooting and killing her husband with the .357 revolver that he had made a statement about, called the police and said, I shot him, and the only evidence that could go in to show of his fear and that it was strictly going to her intent to kill was this statement that was made by the unavailable witness in that case. There was no other witness that could testify other than the witness that did testify under the statement of recent perception to what the decedent in that case said. The fact of what he said. So we have other channels in this case for that evidence to come in. So the defense would maintain the position that under the statement of recent perception and pursuant to the case law, that this information would not be admissible through Michael Campbell. And the reason for that, and the reason for that underlying policy or honor, is because it goes to the essence of what we try to avoid from hearsay, which is this telephone effect of what was said. So why not ask Sadie Beecham what she told to Mr. Gutierrez, which she had a more direct stream of information from? Additionally, an issue that the defense wants to outline is that in the state's recollection of what Mr. Campbell would say, it was clear that the state once again has information that was not disclosed to the defense. This whole thing of them being at a dinner and Erica Saylor's there and Michael Campbell's there and they're having this conversation over dinner, we've never been provided any of that. And that's nowhere in any of Michael Campbell's statements, nowhere in anything that's been provided to the defense. So I don't think it's appropriate now to say, oh, we're going to talk about this conversation that had a dinner. The state purported it happened on May 13th to May 15th. I've had no time to investigate that, to whether there was actually they had a dinner at that time. It just seems a little bizarre that this would be coming up at this moment, and then an attempt to use a rule that really doesn't apply to this factual scenario of this case. So the defense would ask that the court not apply the statement of recent perception exception to Mr. Campbell's statements that he will testify to, or the statements of Mr. Gutierrez that Michael Campbell will testify to. There's other witnesses that are available to testify to that exact evidence. That's the proper way for it to come in. And additionally, we have another issue of disclosure. So under that scope, any information about this dinner that was allegedly had where these conversations were held, we'd ask that that be excluded since we were not provided that information prior to right now.
So the discovery statute is very clear, and counsel and I, without me talking about that, any discussions with counsel, I just want to be sure the court is aware of what my obligations are and sort of how circumstances happen in trial and how we are not out of compliance. So let's start there. So the statute requires that upon demand, the state require written or recorded statements of any witness. Written or recorded. Recorded is defined in the statute, ultimately in the case law, and it means an audio or visual recording. It does not mean something that you've heard verbally. That is not in Wisconsin statutes meaning. So the question is, was it audio recorded or video recorded, or was it a written statement? Or, of course, we have to provide exculpatory information. So obviously what happened was last night, the court had given us some guidance about hearsay. In my discussions this morning with both of these two witnesses, I had discussions with them where Michael Campbell described a few circumstances to me about how he thought some of his discussions were at work. And Erica Saylor told me Michael Campbell and I were both eating dinner during the week before he went missing, and this was said to us at dinner. And that's what was said to me verbally. I don't take audio recordings. I'm not wearing any kind of recording device. I don't have a video recorder with me, and I'm not taking written statements. I'm a prosecutor in the DA's office. I have no other statutory obligation, and that is the state of the law. Counsel may disagree with that or wish the law to be different, but that's the state of the law. And it is a perfect reflection of what happens in a trial, right, where an issue will come up, and I, not shockingly at all, will ask witnesses additional questions about what they know about certain things that have come up in trial. I'm not allowed to share with them what's been testified to, obviously, but I'm allowed to ask them questions about the same things that have come up in issues. If I was obligated to provide some kind of written documentation of each of those, it would be impossible to ever have a trial where you did not organize every bit of information at the trial. And that's just not possible. The court has presided over many trials and knows that that would be impossible to do. So this is an expectation that is not in Wisconsin statutes or case law. This is not required. Judge, I want to indicate the other foundation of what counsel just said was that State v. Weed is a predicated decision based on how crucial that bit of evidence was about that oral statement that was made. And again, I've just provided State v. Weed to counsel, so I don't expect them to be experts on the case. I gave it to them just before the court arrived today. But State v. Weed does not stand at all for the proposition that counsel just stated. So on page 10 of the submission, at the very first paragraph up there, the Supreme Court outlines all of the stuff. It begins on page 9 in the final paragraph, so it's numbered paragraph 31. This is the piece of information that counsel just argued to you was decided and agreed to admit in this court because it was the key piece of evidence. Instead, what the state Supreme Court says in Weed, in paragraph 31, I'm quoting, the hearsay statement was a minor piece of evidence in the state's court case against Weed. Although the statement had some probative value, that's what I'm suggesting here, it has some minor probative value, it was not a significant part of the case. And then they go on to outline the many pieces of evidence that were more significant. And they list, I'm not going to go through them all, but they certainly list 4 distinct pieces of evidence that they prefer to this piece of evidence. So paragraph 31 is in direct opposition to the argument just made by counsel. This is a case indicating this hearsay exception is allowed for not something that it has to be the crucial piece of information. It's a piece of information that is that anyhow has some importance, has some role that the prosecutor feels is important. In this case, they thought it bolstered intent in the Weed case. In my case, I'm simply indicating that it allows the jury to have an explanation why the people who are the recipients of the declarant's information proceed as they do. So, Judge, let me briefly talk about being unavailable because the court has expressed that. So, again, the definition of unavailability is that a individual is absent from the hearing. Clearly, Rosalio Gutierrez is absent from this hearing, and the proponent of the declarations of the declarant's statement has been unable to procure the declarant's attendance by process or other reasonable means. So here's what we've done. We've consulted each of his close friends and family. They haven't heard from him. We have searched multiple locations. We have not been able to find him. We have detected, and the lab has analyzed, his blood located all throughout his home in various rooms, basically every room but the bathroom and the bedroom, including a volume of blood such that there is significant seepage on the couch and on the living room rug. And then we have further discovered the blood of Rosalio Gutierrez in a van that is certainly under the control and ownership of the defendant. and we have a number of pieces of evidence, both circumstantial and real, and otherwise other than circumstantial, which indicate that this individual, Rosalio Gutierrez, is unavailable not only to us, but to all the other people who know him. That is, from the state's perspective, certainly sufficient to declare him unavailable. State v. Weed, again, stands for the proposition, and then if the court wishes to think about Crawford, obviously the decisive piece, in fact, the only piece of analysis needed there is it testimonial? Based on the circumstances that I'm not going to repeat, this is the opposite of testimonial.
I guess I'm a little confused as to then the relevance of this statement. If the state could say what is the relevance then of introducing this statement? Because if it's not to show that my client had allegedly done something that was in violation of a law, then I don't see how it's relevant. But if he's introducing it to
I think he's satisfactorily explained why he wants to do it and why he thinks he can, which he shares with enormous numbers of attorneys and particularly prosecutors who drag hearsay through the door all the time when judges let them by responding when they're called for the fact that it's hearsay. They say it's not being offered to prove the truth of the matter asserted. It's being offered to explain why the person took the next step that they're going to go to, which, as you have correctly pointed out on prior occasions in this case, is irrelevant. The problem that I'm having with accepting it, because there are plenty of judges who would let this in, and he knows that, because they buy into that. I was educated that's not a proper admission of evidence. And I continue to think that is the correct interpretation. And in this particular case, I could even succumb to his suggestion that it's not offered to prove the truth of the matter asserted. And I believe that. I think he's sincere in that, but as I said before, I was concerned about hearsay seepage, and that this evidence, even if I deem it not offered to prove the matter asserted, it's still so pregnant with I don't want to say inflammatory evidence, but motivational evidence, among other things, that I think the risk is too high. And as I've never done that before. In 40 years up here, I have never, ever told a jury, you're hearing so much evidence that would ordinarily be classified as hearsay, but you open the door, and it may well be that if I admitted this, it would come in through the same gateway. He wants to prove, that these two men went up to the defendant's residence because they wanted to get more information about somebody who they thought might be involved because of prior acts involving Mr. Gutierrez.
If I could be heard on that, and I wasn't quite done with the whole relevancy.
Excuse me?
I wasn't, if I just might be heard, I wasn't quite.
Excuse me for cutting you off.
Oh, no, it's fine. There's already been evidence that's been introduced as to why Mr. Campbell went to Mr. Anderson's home. The evidence that's come in has been that Eileen Knoll had texted Mr. Campbell Zach's name, and that then Erica Saylor took that name and looked it up. The evidence that's come in has not been, oh, we were having a dinner with Mr. Gutierrez and he told us all of this, and so then I knew based on that conversation I needed to go do X. The testimony that's come in is that Mr. Campbell has acted in a way because of what was told to him by Eileen Knoll. He was given a name, they looked him up, that's how he then got the address and went on his way. Additionally, the defense at no point has said that it's the lack of investigation of friends that led to Mr. Anderson sitting at table. It's the police. Mr. Campbell is not the police. So to then try to make the inference and the jump that the defense in its opening statement attacking the police interrogation allows for all hearsay about what lay witnesses did next is relevant, the defense would adamantly disagree with that. And so the state now saying they're trying to introduce this, it's relevant to show why Mr. Campbell took the next steps. They've already established why he took the next steps. This is something else. We can't just have a plethora of information going to the same thing. And at that point, Judge, is critical because then that just goes to show how there really is no probative value. And the state even admitted the probative value is minimal. Those were the exact words that the state said. So if the probative value is so minimal that the underlying policy pursuant to the case law that I cited was that it should really only come in if there's no other available evidence. We have available evidence. There's been additional explanations of why Mr. Campbell went to Mr. Zachariah Anderson. This evidence should be excluded.
Well, I quoted Weed as saying that the evidence was minimal. I in no way meant to say that this evidence was minimal. I merely meant to indicate that it had a very specific and limited purpose, which was to explain what happened. You know, counsel wishes there to be a world where you can argue to a jury, hey, these people did some shady things. They showed up at the scene. You know, why did they show up at the scene when the cops have just, you know, gotten there just hours earlier? Why do they show up at Mr. Anderson's home? And the clear implication of these things are that these people are doing things to either block and obstruct an investigation or that they are in on it in some fashion. Because that's why you explain these things as suspicious or worthy of further investigation. You know, one of the things counsel asked you yesterday out of the presence of the jury, which was appreciated, was to be able to get into evidence about Mr. Campbell and whether he went to Pheasant Run landfill the day after. You know, why are you interested in whether he went to a landfill? Why would that be relevant unless you are intending a jury to believe that Mr. Campbell is involved in this homicide and is now dumping evidence of that homicide? Otherwise, why would you care whether he has visited a landfill the day after, not when the body's discovered, but the day after he goes missing, before the body is even discovered by law enforcement? There's no other purpose in doing that.
You said body, you meant
what?
event.
Did I say discovered?
Body.
The missings and the bloody scene and missing Rosalio Gutierrez was discovered. I apologize, Judge, for that factual inaccuracy. So, you know, the counsel wishes there to be a world where those things can be implied directly, both in your opening and in your cross-examination of the various witnesses, and that the state, in response, must be left with simply the cryptic idea that one person provided a name and address in a text to another person without any explanation, and that suddenly two people are going to visit that individual before the police even get there. Cryptically, what is a jury to piece together there in the context of all the other allegations that have been suggested here? What would be reasonable interpretations from the jury based on that evidence? Why would they have Zachariah Anderson's name and address without any context and be so concerned that they would head over there? Well, certainly a very logical conclusion on that was that they're in on it, that they have done something, or maybe they're busy framing him, right, or something like that, where none of those things are a part of what the state is suggesting, which is that there's this limited piece of evidence which gives context so the jury has an alternative explanation as to why that occurs. And so that is why we're doing this. Counsel said that the mere name and address satisfies the requirement. My analogy to that, Judge, would be if somebody went to someone's home or did something new that counsel wanted to consider shady because they had been shot, and the defense said, well, all you should be able to do is say that you've discovered a bullet. You shouldn't be able to say that you were wounded by that bullet, or that you have some information about who shot that bullet. You should only be able to say that a bullet was discovered nearby you, and not have any context about why the next thing occurs. So, I understand the defense preference is to simply have information like a name and address be sufficient, but I think the Weed case does stand for the proposition that this is admissible, and I am satisfied with the court offering a limited instruction. If, as this is said, the court wishes to again tell the jury, this is not to say that anything that you've just heard about this conversation is that it is true. It is simply so that you have some idea, one of the reasons or a possible reason why witnesses proceeded in the fashion that they acted next. I'm totally comfortable with the court doing that, so that it would be even more in violation of what the court had instructed a jury for me to ever argue that this is true because these people heard it, over dinner or at the workplace.
I was trying to find the text messages that were asked of Eileen Knoll. I don't know where they are.
Were all of them testified to? I apologize. I'm going to bring one other thing up while you look.
No,
So,
I found it. I'd like to.
okay, so
No, let him finish.
So the indication that, well, there's going to be witnesses, Olivia and Sadie are going to say these things, which is true, and so therefore they're coming in from other means. I agree with that, Judge, and that increases the indicia of reliability of these two things, because two people will testify who are direct persons on that, and so the fact that Rosalio perceives information from those makes them more reliable, because they will testify or have been documented with law enforcement in recorded interviews as saying that these things occurred. So this is not, you're not being asked to allow evidence on something where there's not a well-grounded reason to anticipate that this information will then come out substantively to the jury. Olivia's going to, the daughter will testify in this case. She's already been recorded with law enforcement describing the circumstances we talked about, that I talked about in my opening. And Sadie Beecham will also testify. She's, whatever happens, and I anticipate she'll testify the same, but even if for some reason that did not occur, if the court thinks of all the different possibilities, she also has been documented fully regarding what she said at the time. So this, it's bolstered by the fact that the evidence of these circumstances will come in.
Yesterday, the state, with Eileen Knoll, discussed and moved into evidence State's Exhibit 245. In that, it's a text message string between Eileen Knoll and Michael Campbell. Eileen Knoll sent her text, "She and her baby daddy need to be investigated like right fucking now." Testified to, that was understanding that was Sadie. Mike, or Eileen, "I agree. I'm calling the detective at 7 in a meeting till then." And then Eileen gives Michael Campbell his Zachariah Anderson's name. I don't understand, is the state asking now to introduce every single little thing that might have led Mr. Campbell to going to Mr. Anderson's home? If that's the case, then the probative value is extremely minimal.
Judge, I'm going to object to the characterization of what was actually presented. Given your rulings yesterday, the only piece of that was actually presented was page 2, the name Zachariah Anderson.
Sure, but she had testified to that she had given this information and had this conversation with Mike Campbell.
Right, but all the context behind it was never allowed to be gone into yesterday based on that ruling before the Weed case. So the name Zachariah Anderson was allowed to be presented. Nothing else from the context was. So when that exhibit was admitted, page 2 was admitted, and actually the only thing allowed on page 2, because they wanted the first one redacted itself, was the name Zachariah Anderson.
As I mentioned, the state's already introduced how Mr. Campbell got this information. It was then based on the testimony that we've already heard that Erica Saylor had looked up Mr. Anderson's information based on getting the name from Eileen Knoll, that's how they then did their next steps. That establishes all of the next steps. The state can establish the fact about what allegedly occurred in Mr. Gutierrez's truck on April 24th, 2020, or late night hours into April 25th, with the witnesses who can actually testify to that.
Well, the bottom line is that I think you've satisfied the requirement of unavailability. I'm still at the same, well, not exactly the same, but somewhat the same position I was on the what is a perception. And I would expect to see, I don't recall ever seeing a statement of recent perception, certainly not one of any significance or over which there was a big objection in a criminal case. And there's a reason for that.
Well, the weed case is a criminal case. So.
Other than, I meant in my trial practice,
Oh.
in the years I've been here, it's a new rule, relatively. Not anymore. It's not as new as it once was, but the Supreme Court of the United States has made reference to that, and it's not being a firmly rooted in the Ohio versus Roberts, firmly rooted exception to the hearsay rule, unlike the excited utterance. And what the rule of statement of recent perception attempts to do is expand the firmly rooted exception of spontaneity from a statement of, excited utterance, which was, they cite as 200 years old, and the law in many states opposing the statement of recent perception, of which Wisconsin is only one of a limited number of states that have adopted the rule, and I'd call it the statement of reflected recent perception. It's what the person perceives in the inclusive sense.
Yep.
In addition to his or her own perceptions. So I have encountered it sometimes in civil cases, and I frankly don't even remember how I've ruled on it, but we are much more expansive in admission in civil cases than in criminal for obvious reasons. But this could come in on the statement of recent perception in a civil case using the expansive use of the word perceive. As well, I was involved in a collision out here on the corner 10 days ago, and I, as many people do in civil cases, when they're asked how long before the collision did you see the oncoming car, the striking car, and they say 2 feet. Well, that's crazy. And of course, all that does is prove you've got enormous contributory negligence because you weren't watching the road. So instead of being confined to that, the person 10 days later, after talking to his friends and neighbors and hearing from them, you yourself never drive more than 25 miles an hour, and this guy must have really been barreling if he came on you that fast, and getting a wide array of information. Come to realize or understand. So 10 days later, the plaintiff concludes and perceives that the other motorist had to have been going about 40. And that becomes his statement of recent perception. It happened only 10 days ago. He made some excited utterances, but of course, the fact that he said only 2 feet away, that's just reflective of the fact that people are wildly inaccurate about distances, and the confusion of the moment, and it's got the spontaneity. But this one is actually on reflection. He had more chance to think about it. Well, under the common law, more chance to think about it translated into more opportunity to think of a big lie.
What? I apologize.
To think up a big lie.
Okay.
That's why we had the excited utterance rule. So you've made a very splendid presentation, but I'm still where I was yesterday. So, are we ready to go?
Yes.
Okay, thank you.
Hi, this is Donna.
That's one. Oh, here we are.
Hello.
Would you come down, please?
Sure.
Good morning, and thank you. You can be seated. Good morning, and thank you for your patience, folks. The entire time we spent, we were disputing an evidentiary issue, and if you were law students, you might actually have found it educational. I did. But it did take that long to do, and I apologize that it was you had to wait. And but anyway, we're back and ready to go now, and you may proceed.
Thank you, Your Honor. So, Mr. Campbell, you were sworn in yesterday. You recall?
Yes.
Okay. So when last I was speaking to you, I was asking if you, on the date of May 19th, 2022, began to have contact with a person named Eileen Knoll.
Yes.
Okay. And do you remember how that, what means of contact? Was that in person, by phone, by text? How was that happening, if you recall?
By text.
So I'm going to show you what's been marked as State's Exhibit 244. That's all. So I'm going to first show you page 1 of that. Can you read that from where you're located? When I stop moving it?
Yes.
Okay. And does this indicate a time that you received, that a text was received by you?
Does it have a time you
Yep.
asked? Yes.
And what's the time on there?
2:09.
And is that on May 19th?
Yes.
Okay. So would that be 2:09 in the afternoon?
Yes.
Okay. And is this a copy of the text you first received from a person you knew to be named Eileen Knoll regarding Rosalía Gutierrez?
Yes.
And could you read that text for the jury? Can you see it well enough to read it?
Yes.
Okay. So just in case they're having any trouble reading it, could you read the text you received?
Hi, Mike. Sorry to bother you. Have you heard from Rosalio the last couple of days? I've tried to call, but go straight to voicemail.
Okay. So do you recall getting that particular text?
Yes.
And then I'm going to ask you about this text, starting at the top. And again, this is the State's Exhibit 242 on the second page. Did you get a follow-up text at what looks like
I'm just going to object and interrupt. Previously, the state had said they're looking at Exhibit 244. So is this 244 or 242?
I apologize. It says State 244. Did I misstate the number earlier?
Just now you said 242.
Apologize. So again, State 244. Did you get a text at 2:08:55?
Yes.
Okay. Was the prior text 2:08:47 that I showed you just a minute ago?
Yes.
All right. Is this again a text to you?
Yes.
And what does this text say, if you could read it?
This is Eileen, by the way.
Okay. And then you read it at 2:09:16. Is that right?
Yes.
All right. Then if I proceed further, there's blue and there's green. Does the green appear to be your answer?
Yes.
Is that again to Eileen Knoll?
Yes.
And did you send that at 2:09:55?
Yes.
Okay. And what did you respond to Eileen Knoll at that 2:09:55 again on the 19th of May?
I seen him Saturday. Is everything okay?
And then did Ms. Knoll then respond to you at that to that text?
Yes.
And is that a text that where it appears to have been sent to you at 2:11 p.m. 2:11:32 p.m. on May 19th?
Yes.
What does that text say in response to your text?
I was checking to see if he was able to get the lights installed in that other unit in hall.
And then if we go on, again, this is State's Exhibit 244. Now this is page 3 of the submission. Does Eileen Knoll text you some additional information?
Yes.
And does it appear that text occurs at 2:11 p.m. and 55 seconds, again, May 19th?
Yes.
What does Eileen Knoll now communicate to you in this text?
Just making sure he's okay. Not like him to have his phone off.
Do you agree that it wasn't like him to have his phone off?
Yeah.
Okay. I'm going to ask you to take a look at the green. Again, are those your responses in the context of what we're showing?
Yep.
Okay. Let's see if I can orient that. And so is that an answer that you sent to Eileen Knoll, again, 2:12 p.m. and 59 seconds on May 19th.
Yes.
Okay, so what do you tell Eileen Knoll?
I'm going to do some detective work.
And then at that point, does Eileen Knoll respond to you at 2:20 and 41 seconds, again, May 19th?
Yes.
What does she say?
Okay, thanks. Just making sure he's okay.
Okay. So to the extent you remember, what, if any, detective work did you do at that time? What's the next thing you did?
We went home. I went home and spoke with my girlfriend and told her about the situation, and she started looking stuff up.
Before you
Public
did,
information.
Hold on. Before you did that, did you go to the scene? Did you go to Rosalio's house?
Yes, yes, yes.
Okay. So when I asked what happened next, after you said, okay, I'm going to do some detective work, had you been to the scene yet at that time?
No.
Okay. So then, how long would you estimate it was from the last text sent to you, 2:20 p.m., how long was it before you went over to Rosalio's house after that text from Aileen?
Within the hour for sure, because I live very close to him.
Okay. So, and then you indicated what happened when you went over. We talked about that yesterday, correct? Did you testify to that previously yesterday?
Yes.
Okay. Now, after being at the scene, did you come to believe, based on being at the scene, that Rosalio Gutierrez was missing?
I was.
I'm going to object as far as his opinion to whether an individual is missing. It's being speculative.
Again, I believe he receives information that causes him to do things next. So he has a short interaction. At that point, he believes. Okay, go ahead. Did you come to believe that Rosalio was missing based on what was occurring at the scene?
Yeah.
Okay, as opposed to there being a dead body in there.
Objection, argumentative, and leading and speculative. This witness did not go into Mr. Gutierrez's apartment.
Rephrase your question.
What did you perceive when you were at the scene and interacted briefly at the scene of Rosalio Gutierrez's apartment? Did you leave that scene believing that someone was inside?
I'm going to object. This is leading as far as did you and then provide.
Overruled. Did you perceive that there was a body inside, or that Rosalio Gutierrez was missing?
I was told he was missing.
Okay. So after having found out, after having perceived that Rosalio Gutierrez was missing, where did you go next after being at the home of Rosalio Gutierrez?
I went to my house.
Okay. And were you allowed inside Rosalio Gutierrez's home while you were at the scene?
Of course not.
Okay. Had you made any attempts, if you recall, to call Rosalio Gutierrez on that day, the 19th?
After I talked to the police?
Anytime. Anytime that day did you attempt to call him?
Honestly, I don't remember.
Okay. Now, after believing that Rosalio Gutierrez was missing, where did you go next? Physically, where did you go?
After I left the crime scene,
Yep.
I went to my house.
Okay. And when you got there, who was home?
My girlfriend, Erica.
And did you then, what, if anything, did you place on social media while you were home?
Basically made a post asking if anybody's seen my friend Rosalio.
Why did you do that?
Social media, I mean, it can get spread, you know? So I just was concerned.
Okay. What were you hoping to accomplish? What were you hoping to have happen?
Somebody knows where he's at.
Okay. And after having posted that, were you in contact with somebody that you knew who ended up arriving at the residence?
Yes.
And who was that?
Brandon
And what's Brandon's last name, if you could tell us?
Hendrickson.
And if you can estimate in a general sense, what time did Brandon Hendrickson arrive?
Probably like 3-ish, 4-ish, somewhere around in there. I mean, I don't have an exact time.
And when he arrived, what did you discuss with Brandon Hendrickson?
Basically, let's go talk to the guy.
And at some point, were you present when some determination was tried to be made about this? First of all, when you say the guy, when you originally arrived home, did you know the name of any guy to look for, a specific name?
Maybe first name, just because of prior conversations I've had with Rosalio. But until, obviously, Erica was looking stuff up, that's when I knew first and last.
Who's Erica?
My ex-girlfriend.
Did you also, what if anything can you say about whether Eileen Knoll was also trying or providing names at any point to you?
Yeah, she had mentioned his name as well to me.
Okay, and so did she provide the name Zachariah Anderson to you?
Yes.
Okay, and you said Erica was also looking it up. Were you present when that occurred?
Yeah.
And based on the Eileen Knoll text as well as whatever Erica was doing, did you have a name of someone who you were at least interested in?
Yes.
And did you have an address ultimately that you were interested in?
Yes.
And what conversation did you have, if any, with Brandon Hendrickson at the point that you knew a name and an address?
No really conversation was made. We just left.
Why?
Because I was concerned about my missing friend.
So what were you thinking to accomplish if you had a thought process? What were you hoping that might occur?
To see his reaction to, you know, conversation that I'm having with him, and, you know, just kind of figure it out myself.
And you had already spoken to law enforcement, at least briefly already?
Right.
Okay. Did law enforcement have any idea you were going to go to find a person who you had identified as Zachariah Anderson?
Definitely not.
Okay. So who went along?
Me and Brandon.
Who drove?
I did.
What vehicle was used?
My mom's car.
And in general, where did you go to?
To his house.
Okay. Do you remember where that was in general?
I had no idea where I was at. I GPS'd it.
Okay. And had you ever been to, what if anything can you say about whether you've ever been to that location before in your life?
I'm a general contractor. I'm all over. So I've never been in his area, you know.
Okay. So you had not been to this area that your GPS took you to?
Right.
Okay.
Yeah.
And did you know what Zachariah Anderson looked like when you drove?
No.
Can you give me an estimate on how long it took you to get there?
I think like an hour, something like that.
And what, if you recall, about what time did this drive take place? Again, understanding it was a while ago, about how long did it take to drive there?
Objection asked and answered. He just said
sorry,
about an hour.
I apologize. What time of day did you drive?
It was like afternoon, you know, 4-ish, 5-ish, because it started to get dark when we were, you know, out there.
Okay. So when you drive, do you go straight to that location?
Yes.
All right. And when you arrive where your GPS directs you, what happens next?
We both get out the car. You know, we're walking up to the front door. There was no stairs leading to the front door. I thought that was kind of odd. So I didn't want to jump over his railing to knock on his door. So we walked around to the back, and then that's when I seen Zach, and that's when I engaged to talk to him.
Is the person that you just identified as the person you were speaking to, is that person here in the courtroom today?
Yes.
For purposes of the record, Mr. Campbell, can you point that individual out and say what that person is wearing today?
He is wearing a gray suit with a blue tie.
Indicating the accused.
Mr. Campbell, what was the defendant doing when you first saw him?
He's throwing something away in the dumpster on his phone.
And if you remember, what were the weather conditions like on that particular day when you arrived at his house? Rainy?
It was cloudy.
Okay. And when you were approaching, did you, if you were able to tell, were you able to notice the defendant first, or did he notice you first, if you could tell?
Honestly, when I walked up, it seemed like he kind of had his back to us throwing something in a dumpster, and so I believe I noticed him first.
Okay. And who said something first between them? Okay. And what did you say to the defendant?
Said, hey, I'm here to look for Zachariah Anderson. It's about a friend that is missing, that I have belief that you have something to do with it.
And was Brandon, I'm not asking specifically, but was Brandon Hendrickson also speaking to the defendant at the same time you said what you just said?
Not much. I did most of all the talking.
Okay. What, if anything, what did the defendant say when you said, I'm looking for Zachariah Anderson and I am concerned he might have something to do with my missing friend? What did he say, if anything?
He denied that it was himself. Said he was his brother or something. And that he said he was going to call him or something.
And what happened next?
He went inside.
He is who? Say
Zach.
Okay, that's the defendant?
Yes.
Okay, then what happened?
He went inside, and I don't know what he did. Obviously, he was inside, and then was basically kind of talking to us through the window.
Okay, stop for a second. Where were you at that point?
Still in the driveway.
Okay. When the defendant goes inside, do you change your location in the driveway as best you remember, or do you stay where you were?
We were actually making our way back towards the car, because we didn't know what he was going in the house for. Okay. So I was just being aware of my surroundings.
So how close were you to your car, your mom's car, when you had some interaction with the defendant again?
25, 50 feet.
From your car?
From my car.
Okay, and 25 feet and then towards the house still? 25 feet away from your car in the direction of where his house was located?
Yes.
Okay. And what was the nature of the next interaction between the two of you and the defendant?
He basically said he didn't know anything what we were talking about, so I basically just said, okay, well, I'm sure you'll be talked to by other people, and we left.
Did you tell him who you thought was going to be talking to him?
Yeah.
Who'd you say?
The detectives.
And after you said that, what did you do next?
We left, and then, excuse me, I had enough.
Hold on. So when you said you left, was there still a distance you had to travel to get to the vehicle, or were you already at the vehicle by this time?
As he was telling us that he didn't know what we were talking about, we were basically making our way back to the car.
Okay.
To leave, and then we just left.
All right. And then who left in the car?
Me and Brandon.
Who drove?
I did.
Okay. And when you left the property, was the defendant inside his home or outside of his home?
Honestly, I don't remember.
And at any time during your interaction with the defendant, I'm sorry, I'm going to ask a different question. At any time while you were located on the defendant's property, did you see any vehicles that were not the vehicle you had come on with?
Yes,
Okay.
I've seen two.
Two? And where were they in relation to where you were?
Probably like 30 yards off to my right.
Okay. Were they close to the house or away from the house?
About 30 yards away from the house and myself.
Okay, and what vehicles do you recall?
It was a van. I think it was a black van, and then a Audi.
Okay, and what if any contact did you ever have with the Audi?
None.
What if any contact did you ever have with the van?
None.
What's the closest you ever got to the Audi or the van? What's the closest you ever got to either one of those vehicles?
When I was conversating with the defendant, that was the closest I was. When I was like 5 feet from him.
And after the defendant went in the house, were you headed towards the vehicles or away from the vehicles?
Away from his vehicles.
Okay. And during the time period you were on the defendant's property, was Brandon Hendrickson ever out of your sight?
Nope, right next to me.
Did Brandon Hendrickson ever go up to the Audi or approach the Audi in any way?
No.
Did Brandon Hendrickson ever go to the minivan?
No.
After you drove away, what happened next?
We drove away, and there was a car that I recognized drove past when we showed up there, because it drove past pretty slow. And, you know, I was thinking, like, did he call his friends or something? That was in the back of my mind. We left, that same car was facing the opposite direction, stopped in the middle of a 2-lane highway, and was flicking his lights at us and held like a hat out the window, wanting us to stop, I believe. But we just kept on going because, you know, I didn't know who it was or anything like that.
All right. And what's the next thing you did?
We went to Sadie's house.
Had you ever been to Sadie's house?
Never.
Had you ever met Sadie?
No.
How did you know Sadie's house location?
We looked it up on, I'm not sure how actually Erica got the address, but she looked it up.
Okay. So why'd you go to Sadie's house?
We just went over there. I don't know. I don't have a reason. We just went over there to check stuff out over there, I guess, see if we've seen anything fishy or maybe seen Rosalio or something.
When you got there, what'd you do?
We parked in the bar, probably sat there for a couple of minutes, seen nothing crazy or anything, and we left.
Did you ever go up to the park? Did you ever go up to the house?
No.
Okay. And then when you left, who, if anyone, did you contact in terms of authorities?
I called the authorities after we drove past Zach's house again.
Okay. So what happened when you drove past his house again?
Seen a whole bunch of police vehicles and unmarked, vehicles.
Did you drive by his house again on purpose, like for a reason?
No, we just drove past, because if I'm not mistaken, it was on the way back home.
Okay. And so this time you saw a number of vehicles that were clearly police vehicles?
Mm-hmm.
So what did you do then?
Just went home and then...
I'm sorry, in terms of calling.
Oh, calling. Then I called whatever county I was in, sheriff's department or whatever, to let them know, I was there, I went there to talk to the man. No harm intended. Just wanted to conversate with him.
And did you identify yourself?
Yes, I did.
And ultimately, after having made that contact over at the defendant's house, did Kenosha law enforcement then speak to you about that?
Yes, they were very mad.
Okay. I want to talk about some of your last contacts with Rosalio Gutierrez for a second. Are you aware?
I'm going to object that this tentatively going against the court's ruling about the prior conversations Mr. Campbell had with Mr. Gutierrez.
Yeah, I won't ask those. I understand the court's ruling.
Okay.
Yeah. did you have an interaction of any kind through any communication with Rosalio Gutierrez about money one of you owed the other on Friday, the 15th of May?
Yes.
Okay. And prior to people beginning to question you about this, did you have any active memory of that until people started bringing this up to you?
Say that again?
Did you remember this interaction about money with Rosalio Gutierrez before people began to ask you questions about it, or is that only something that's familiar to you because people said to you, hey, what about this?
I'm going to object. It's leading and suggestive.
It provides multiple options.
Only two options, and so then it's compound, and it's only giving him one of an answer. So therefore, it's suggestive and leading.
Oral.
Should I do it again?
Ask again, please.
Yeah. So did you remember this this contact about money owed before anybody asked you about it, or was your memory only jogged about it when people talked to you about it? Which of those?
I worked with him. He owed me money a lot. So, I don't remember specific, conversations about we did this house or whatever.
So, are you now aware, and do you now recall that on May 15th you received a text from Rosalio Gutierrez about money he owed you?
Objection, leading.
I'm just orienting us
I'll
so we
withdraw
can.
the objection, given the answer.
Thanks. So now I'm going to show you what's. Is this on the?
So it's State's Exhibit 1.
So this is going to come up on that screen.
The number?
So no, it's yes. So it's State's 1, 335, page 71 of the last page. Correct.
Okay.
Okay, do you see up there a display that appears to be phone records?
Yes.
And can you see a text that's dated at on May 15th at 6:03 p.m.?
Yes.
And is that incoming to your phone?
Yes.
And is that from a person who is identified in your phone as Junior?
Yes.
Who is the person who was identified in your phone as Junior back on May 15th, 2020?
Ask that again?
Who was identified in your phone as Junior back on May 15th, 2020?
Rosalio.
Same person we've been talking about?
Correct.
So did he send you a text then at 6:03 p.m. on May 15th?
Yes.
And what does that text say?
You want me to come pay you before I get Julian and shower?
And there's a male name listed there, right?
There's what?
There's a name of a male individual there without saying the name, right?
Yes.
Who is that person? Is that a person when Junior texted you that, did you immediately know who he was referring to?
Yes.
Who is that person without saying their name?
His son.
Okay. So in response to...
I'm just going to object and ask, it's not really an objection, but I think we need to discuss something with Judge.
It's time for a break. Please don't talk about the case during the break. We'll start again in about 15 minutes. Yeah.
I missed what you were saying.
No, that's all right. All right, let's continue, Mr. Ridley.
So again, I want to direct your attention first to the text that you've already read, 5/15/2020, 6:03 p.m. Do you want me to come pay you before I get the person you've identified as Rosalio's son and shower? Do you answer that text?
Yes.
And is the answer to that text on, again, May 15th, 2020, at 6:05 p.m., so a couple minutes after?
Yes.
And what is it that you say in relation to, do you want me to come and pay you?
No, it's okay. I can wait.
Okay. Now, on the 15th of May, if I indicated to you that was a Friday, do you believe you saw Rosalio Gutierrez after that before you went to his house because you were concerned about his whereabouts? So after that Friday at 6:05, do you think you saw him sometime that weekend, for instance?
It's possible, yes.
Okay. And you have a memory of believing that you saw him sometime that weekend?
I don't have a memory, but like I said, it's possible that I could have seen him, yes.
Did you give a statement to law enforcement back on May 20th, 2020?
Yes.
So that was literally the day after you had been over to the crime scene, is that right?
Yeah.
Okay. That was very recent in terms of us talking about the weekend of May 16th and 17th, just a couple days before.
Yeah.
All right. If I showed you that statement that you gave law enforcement, would that possibly refresh your memory of whether you saw Rosalio on sometime that weekend?
Yeah.
Okay. So I'm just going to point it out to you so he sees that portion. Okay. So I'm going to show you what's been marked as State's Exhibit 238. I'm going to direct your attention. I'm just going to point right there. If you could read those next couple of sentences to yourself, okay? Have you read those?
Yes.
Does that refresh your memory about whether you saw Rosalio Gutierrez sometime that same weekend of the 15th, 16th, 17th of May 2020?
Yes.
So now, having had your memory refreshed, approximately when do you think you saw him, and in what context? What do you know about it?
It was either, Friday or Saturday when we had pizza, all the kids together.
And do you believe that was at Rosalio Gutierrez's house or your house?
My house.
Okay. Now, after that, I'm going to call it pizza party. Okay. After that pizza party,
I'm going to object that it hasn't been testified to that there was a pizza party.
They didn't make it one.
So then, argumentative in testimony.
Overall.
after that incident where you had pizza and the children together at your house, is there ever a time that you have a distinct memory of seeing Rosalio Gutierrez in person again, other than that gathering we just talked about?
No, I think that was probably the last time I'd seen him.
Okay. Now, are you aware that your phone, what if anything can you say about whether you gave up your phone willingly and cooperatively in this case when law enforcement asked you in some fashion?
Yeah, I gave him, any information I could.
Okay. And ultimately, are you aware that your phone indicates that on May 17th, 2020, at 1:46 a.m., okay, so the Saturday into very early Sunday morning, right?
Mm-hmm.
1:46 a.m., that your phone is at a location at Rosalio Gutierrez's home. Are you aware of that?
Yes, I was told about it, yes.
That's been pointed out to you?
Yes.
Okay. What if anything, do you remember about, by May 17th, 2020, were the bars in Kenosha starting to open again?
I believe so, yeah.
Okay. And what, if anything, do you know about May 17th, 2020, and any idea of, you know, first of all, do you have a distinct memory of going to Rosalio Gutierrez's home on May 17th, 2020 at 1:46 a.m.?
If I were to be there, it would be to just hang out with him, drink a couple beers or something. I honestly don't remember. But that, you know, obviously if I'm going over there at that time, after the bar, we're going to hang out and drink a couple beers.
Okay. And then on May 17th, so that's a Sunday, in the evening hours, do you recall where you were?
At my house, I'm sure.
Okay. And can you indicate on May 17th, 2020, what your hairstyle was?
Same it is now, same as it has been since like 9th grade.
And on May 17th, 2020, in the evening, do you recall ever leaving your residence that is was your normal residence at the time?
On Sunday evening, you said?
Yep.
No, other than maybe leaving to go get food or something for the kids and Erica, you know. I mean, if I wasn't at work, I was at home.
And who is Erica to you, specifically back on May 17th, 2020? Who was Erica to you at that moment?
It was my girlfriend at the time.
Okay. And do you have children with her?
One.
One? Okay. And what, if anything, can you say about your living situation back on May 17th, 2020?
I don't...
Were you living with her or apart?
She was living, well, it's my house, so she was at my house living with me at the time.
And the children?
Yes.
Okay. And that was true on the evening of May 17th, 2020?
Yes.
All right. Are you and Miss Saylor romantically connected today? At
No.
this time? Okay. Now, you've heard a person brought up at some point named Sadie Beecham. Is that a name you've heard at least today?
I wasn't sure her last name was that. I just knew of it on Facebook, Sadie Jane.
Okay. And up to May 19th, when you go to the crime scene, had you ever been in touch where there had been mutual contact with Sadie Beecham or Sadie Jane?
No.
Had you ever met Sadie Beecham or Sadie Jane in person before you went to the crime scene on May 19th?
No.
And after you went to the crime scene on May 19th, did you at some point later on May 19th reach out or attempt to reach out to Sadie Beecham, Sadie Jane?
Yes.
And what's the first, if you know, what's the first way you tried to do that?
Facebook.
Okay.
Messenger.
And originally, did you receive any responses originally?
It was quite some time. That day I did receive responses, but it was hours later, I believe.
Okay. And that you think you reached out on Facebook?
Yes.
Okay.
For sure I did.
All right. And then you also went to her home and parked at a bar across the street?
Objection, assumes a fact not in evidence about parking in a bar across the street.
He actually said that in his testimony.
Oh, I must have missed.
It's predicated upon that, and if you find that if that hasn't been proved, disregard the answer.
Was the bar that I'm speaking about that you said you parked at, was it across the street?
No, it was like her house was here, and then the parking lot was like kind of on the side of her house.
Okay. So that day, May 19th, you also went to that location, right?
The day after, yeah.
The day you found?
The day I went to his house.
Okay. And you didn't make any contact with her in person then?
No.
Okay. So having returned from your trip up north of where you had been, where you live, did you at some point then have contact for the first time with Sadie Beecham?
Yeah, she finally responded back to me.
And you believe that was sometime that evening of May 19th, but after you returned? Did I get that correct?
Yeah.
Okay.
Pretty positive it was after, yep.
No further questions of Mr. Campbell. Thank you, Your Honor.
Going back to May 19th, 2020, I'm going to probably walk you through a couple more things that the state kind of started you on. So you arrived at Mr. Gutierrez's apartment, and then do you remember speaking with detectives when you were there?
Yes.
Okay. And do you remember after you spoke with detectives on scene that you had a telephone conversation with Detective Correa?
I had a conversation with him, I believe, on the way back from my trip up to his house.
Okay. So you did have a phone call.
Yes.
And do you remember in that phone call, the detective...
If you're about to indicate something that was stated, that's hearsay.
Rephrase your question.
Do you remember telling Detective Correa that you had gotten information about Sadie and Mr. Anderson from Miss Patterson?
I didn't get any information from her.
So if you told Detective Correa that you got information about Mr. Anderson and Sadie, that would be a lie?
Objection calls for a conclusion by the witness. He shouldn't have to form an opinion about or vouch for truthfulness of any.
A lie is a very, very...
Sure, I'll rephrase it.
When you say something's a lie, well, a lie is a willful misrepresentation of, well, generally a fact, but there people can be, if you ask me, you know, where was I last December 22nd, and I give you my best estimate, it's probably going to be wrong, but it's not a lie.
Sure. So you never told Detective Correa that you had gotten information about Sadie or Mr. Anderson from Mr. Gutierrez's mother?
I don't recall getting any information from Celia about Zachariah. I got all my information from my ex-girlfriend, like I had stated before.
Okay, and you're standing by that?
Yes.
So on May 19th, 2020, you had never did you speak with Ms. Patterson on that date?
I don't remember when I had spoken with her. Of course, I'm sure she knew me working with her son, so I'm sure she reached out to me. I don't remember when she reached out to me.
So you said you were when you drove to Mr. Gutierrez's apartment on May 19th, 2020, were you driving your own vehicle at that time?
To Mr. Gutierrez's house?
Correct.
Yes.
And what is that vehicle?
2003 GMC Sierra.
What color?
Black.
And that's a pickup truck?
Yes.
And so why did you take a different car? Why didn't you drive your truck to Mr. Anderson's home?
Because I don't live far from Junior. My car isn't the greatest. It's a work truck. My mother's car is a lot more reliable.
Did it have anything to do with the fact, too, about your license status?
Objection, that sounds argumentative and...
What's the relevance?
Well, it's relevance as to the credibility of this witness.
what his license status is? Objection.
If the court wants me to give an offer of proof, I can come up.
I can't imagine what offer of proof you would give that would change my mind. This is something that you're required to approach prior to asking the question.
So I'm going to ask that it be stricken, so that and the jury be
Well, if I could
instructed.
approach.
And let me finish, counsel. And that the jury be instructed not to pay that they should not consider this question in any fashion.
The driving status is not a proper consideration in evaluating this testimony. We have rules about this type of thing. That's what I referred to in talking to Ms. Miller, which have not been satisfied, and there are prerequisites that the court has to evaluate. So disregard the question, and if there was an answer, disregard that as well.
Your mother's car, what is that vehicle?
Kia, I'm not, Optima or something.
And the color?
Burgundy.
So when you arrived at Mr. Anderson's residence on May 19th, 2020, you had noted that you first attempted to walk right up to the front of the building?
To the front of the house, yes.
So that was through the grass?
Correct.
Then you walked around?
Correct.
And that's when you saw the two vehicles and Mr. Anderson?
I saw him first.
And then the two vehicles?
Yes.
Okay. When you were there, you said that Mr. Anderson had said that he was his brother?
Something like that, yeah. He said he didn't say that it was him.
Okay.
I
And,
asked him if it was Zachariah. He said no.
and did you give your real name?
I did. I didn't give him my last, I don't think, but I gave him my first.
Okay. And did you hear Mr. Hendrickson
Objection.
give his name?
Objection. Calls for hearsay. What the other person said?
The other person's already testified, and this is also the state.
The
This is just.
no, please. Can you give me the question back, please?
Did you hear Mr. Hendrickson give his name?
Overall,
He didn't give his name, no.
He didn't give his real name. He gave
Correct.
a fake name.
Correct. First fake name.
Okay. So Mr. Anderson wasn't the only one not giving real names in that situation, in that conversation.
Objection. That's argumentative.
It's factual, Judge.
Well, the court has.
overall,
You can answer.
Yeah.
So when you were there and you made these observations, did you see anyone in the black van?
No.
Did you see anyone cutting carpet out of that black van?
No.
Did you see a fire that was going?
No, I did not.
Okay. And were you able to observe what Mr. Anderson was wearing?
I don't recall.
Okay. And you didn't see your friend there, correct?
What do you, no.
Your friend that you went looking for?
No.
You didn't see him there?
No.
And you didn't see any of his belongings there?
No.
What was you had said that your intent of going there was to just ask questions?
Mm-hmm.
So, but did you assume that Mr. Anderson had something to do?
With this?
Yes.
Of course.
And so you drove over an hour just to have a conversation with someone that you believed had something to do with the disappearance of your friend,
Yeah, I did.
with the only intent being to have a conversation with the guy.
Yes.
Well, what would you have done you saw Mr. Gutierrez there.
Objection calls for speculation.
Sustained.
Your intent could have been more than to just have a conversation.
If he saw his
Yeah,
friend there-
you-
Hold on for a second. The question is if he
If there's
saw.
an objection, state the objection.
I don't know.
Well, I'm not sure that he's understanding your question, and I
correct.
have
I'll
to tell you,
I'll rephrase it.
in the form in which it's placed, it's, yeah, ask it over again.
You had, I'm just going to ask a different question. So you drove over an hour to see someone that might have, in your opinion, had something to do with your friend's disappearance, just to have a conversation with them?
Yes.
Okay. Do you know an individual named John Hunt?
I do now,
Right. How do you know him?
from a statement that was written from him.
Do you remember previously telling law enforcement that you had known him prior to that you were familiar with who he was?
I was told by my sister that he was my father's friend that I had no idea about.
And do you remember a time around May 19th, 2020, where you and him had an encounter?
I mean, he picked up my sister every day to go to the methadone clinic. So, yeah, I'm sure I had conversations with him.
And around this time, strike that. I want to go back to May 17th, 2020. Your phone pings at Mr. Gutierrez's apartment.
Okay?
But you previously said that the only time you saw him was either on Friday or Saturday. You can't remember.
Objection, that mischaracterizes the evidence. He didn't say that's the only time he saw him. Just said that's the time he saw him. Obviously, it's not the only time. He's seen him many times over his life.
Friday or Saturday, you said that that event was this, as the state said, a pizza party, and that was at your house, correct?
Correct.
So what were you doing at Mr. Gutierrez's apartment on May 17th, 2020?
Like I said, I could have went over there, had some beers with him. You know, if he had a job that I had to go somewhere different, maybe I needed some tools that he had, or vice versa.
But would you have gone there without texting him first?
Objection calls for speculation.
It's this own witness.
I don't, you could ask him whether he did or not, but you're asking whether he would have done so, which is, you're really asking what he might have done, which isn't, well, it's irrelevant. If you,
Before you go to Mr. Gutierrez, you've been to Mr. Gutierrez's apartment before.
Correct.
Normally when you go, do you text or call him and let him know you'll be coming by?
Same
Not
objection.
all the time.
Hold on. Same objection.
This is what he normally does. It's not asking would he. It's habit evidence, Judge.
well, and there are limitations on that, but he can answer.
Say it again?
What she's asking is whether you would typically contact him beforehand that you were coming. I think that's what she's asking.
Yes.
Yeah, normally I would, yeah.
And, but you hadn't texted him on the 17th or called him and told him that you were coming, correct?
I guess not, no.
The state had asked you about Mr. Gutierrez owing you money. You had said there are times, where he owed you money for the work that you guys were doing. Around this time, Mr. Gutierrez owed you some money, correct?
Correct.
Do you remember how much?
No. How would I remember that?
You don't have to say anything further.
What did he owe you money for?
Work,
What kind of work?
painting, flooring, general contracting work.
Now, when you worked, did you ever work with him and other guys, or was it that he would send you out to a job site and you would do it and then he'd pay you?
We worked together. Sometimes we worked separate on different projects that he had going on.
And in working with Mr. Gutierrez and other people, did you ever work with an individual named Dan Spear?
Yes.
And Dan Spear was another individual who did work for Mr. Gutierrez.
I want to say he only did work for him a couple of times.
Was there a reason for that, to your knowledge?
Objection. Irrelevant. I'm not on notice of any information about Mr. Spear and have no reason to believe it's relevant what his reason was of not being employed any
What's
longer.
the relevance?
Its relevance as to conversations between Mr. Gutierrez and Mr. Dan Spear, which were included in the discovery provided by the state to the defense.
Again, Judge, that sounds like hearsay.
It might be, but this question in and of itself,
Well,
the objection is overruled. You
so
can answer.
my objection is speculation as well. How would he know what the circumstances were of Mr. Spear no longer working?
I asked him if he knew.
Do you know the? Do you
Yeah,
understand the question?
I know that he has worked with him. I've actually helped Dan Spear on a job for Eileen, and I don't know any other jobs that they did.
Now, with Mr. Gutierrez owing you money for the work that you've done, do you remember admitting to law enforcement that the only times you really ever got mad at Mr. Gutierrez was over money owed?
The only time I got mad at Mr. Gutierrez was the situation with Dan and Junior.
What happened with that situation?
Junior had him do a tile surround for $150.
And why did that make you angry?
If you understand and know pricing, that's terrible.
What would the norm, and this was something that he was supposed to pay Dan Spear for?
Right, which I had to help because he didn't have the tools or a vehicle to get to the job.
And how much would the pay be for a job like that?
Objection irrelevant, Judge. What we're now talking about is whether Rosalio Gutierrez paid enough money to Dan Spear. Irrelevant. Whether he has knowledge or not, irrelevant.
What is the relevance?
Again, the relevance is going to come out with detectives and the theory of the defense about not investigating people. There are several messages from Dan Spear to Mr. Gutierrez that was provided by the state to the defense. This witness has also testified that that was the only time he got angry. It was a tricky situation. That text message string is a very aggressive text message string about monies owed from Mr. Gutierrez to Dan Spear.
Sounds like
if you were questioning him specifically about the incident, but at this point the relevance has not been demonstrated.
And again, Judge, this is the Denny stuff that we talked about before, and I mean based on the record that was just made.
Not Denny.
Hold, counsel.
All right, that's enough. Just say what you want to say.
Sure. Me?
Please.
Okay. Again, we have an allegation of a named individual where, of a named individual where the basic allegation made is a Denny violation, purporting that underpaying a person for tile work would be something that would be a Denny violation. What possible other explanation would there be for raising this? And again, this is not a name that we've been provided or the court was noticed on.
Lack of police investigation into the discovery into this case.
Well,
This
what
is
about
not
the
an
district
allegation.
attorney's point? What about the district attorney's point?
Point about what? That I've named an individual? It would be coming in with the phone records anyway that he stipulated to.
I didn't stipulate
It's a
any Denny
fact,
violation.
Judge. There's a difference between establishing fact and making a Denny argument. I'm not doing that here. I'm also just inquiring further from a witness's answer. I'm not pointing the finger, nor am I offering to point the finger. I'm offering it as evidence that the state ignored, which is evident because they clearly don't know what I'm talking about right now.
Oh, Judge, that is an improper argument. That's improper. So if every person that a contractor ever has an argument with has to be individually investigated.
Stop. I'm going to ask you folks to just step out for 2 minutes. Please don't talk about the case. When I first became judge, like my colleagues in Wisconsin, I went to the judges' school, and we got pointers from experienced judges and others about various techniques. And one of the points that was made was that you should always give reasons for your ruling, so the Court of Appeals why you ruled as you did. And over the years, I've tried to adhere to that as much as possible, and I can't recall ever getting scolded for it by the Court of Appeals. And in fact, on occasion, individual judges have, from the Court of Appeals, have told me how they like that because they can understand why I acted as I did. That doesn't mean they always agree. But, and so I've been comfortable with it. And I had a case a couple of years ago where I was roundly criticized in a case that was in the national media, which a lot of criticism, in my estimation, was politically based by people who did or didn't like the way things were going. But there was a lot of criticism. You know, the judge shouldn't be ruling on evidence in front of the jury and giving his reasons for doing it, and also allowing the attorneys to argue evidence in front of the jury, which also was, I thought, encouraged by the Court of Appeals. I have to tell you that, and I've been through some real battles in here, but I've never had a case where lawyers took my position of allowing discussion to the point of filibuster. And if we don't contain this a little bit, I'm going to have to go to the more traditional system of just stating your objection, and I'll rule on the fly without always fully understanding what you're getting at. This courtroom was built 100 years ago, and the jurors have to climb 21 steps to get up to the jury room, and it's not comfortable for all of them. So taking these extended breaks for having the evidentiary discussions is a problem, as it is for the reporter because of the electronics if we leave the room. So look, you can briefly state your positions, but both the acrimony and the excessive combativeness are not helpful, and I want them stopped. Any questions?
No, Judge.
No.
Thank you. Ask the jury to come in.
Well, did the court rule on whether this is a permissible question or whether there's a Denny violation, just so that we're...
Oh, I was looking at it as an opportunity to give a speech. All right. And I didn't, actually.
Okay.
Thank you.
Yeah.
Why don't you start with a new question and keep it within the parameters. There is validity to what he's saying. I also can understand your position, which has been pretty consistent throughout the trial. But Rephrase your question and we'll see what's going on.
Yeah, I don't even remember what the last question was at this point.
Are you
So
suggesting this area of a dispute over the money?
Yeah, that's the issue.
I think
Is
I
either
think-
every time, every time this guy has gotten into a disagreement with somebody, whether it was over the fifth inning of the Cubs-Brewers game, 2 years ago, that's so far-fetched. So, the fact that it's a disagreement about money, which the witness says he doesn't even remember the amount, and whatever evidence was received earlier on was or what discussions we had was, we've talked about less than $1,000. So, I think I've already indicated that I thought there was an insufficient ground
yeah,
to go
and
in this depth.
I was finished with my line of questioning about the argument with Dan Spears and that whole issue.
Well,
I think the objection came when this witness answered. It was a late objection. I'm moving on. I'm not going into that area anymore.
I am asking the court to indicate that the testimony garnered regarding a dispute about tile surround with Dan Spears should be disregarded because the court is sustaining my objection, and then we should move on.
I would say I didn't think that the $150 dispute about the tile on the, what do you call it, the edge?
Tub surround.
Tile surround was of such significance that it needs to be struck. So while I think your point is a legitimate one, I'm not going to strike the evidence.
Okay, so you're sustaining my objection, or because she indicates she's moving on, we're not, just so that I understand where we're at, and I'm done.
You made a request in addition to the objection. The objection is I didn't think it amounted to a Denny violation, so I guess I'll overrule your objection.
Okay.
Thank you.
On direct examination, you had talked about a Facebook post that you created in regards to your friend, Mr. Gutierrez. That Facebook post, was that a public post?
Yeah, I think so, yeah.
And you said that you had made that post upon arriving home after you were at Mr. Gutierrez's apartment?
I don't remember exactly when I posted it.
But it was in the late afternoon.
Again, I don't remember when I posted it.
You don't, did you post it, so you don't remember at all?
No.
Previously, do you remember testifying that you had posted it when you got home?
No.
But you wouldn't have posted it before you went to Mr. Gutierrez's apartment, correct?
No.
Okay, so I'm just trying to get a timeline here, Mr. Campbell.
Objection. He indicates he doesn't remember what time.
Well, I can still narrow it down.
Well, not to the point of nausea.
I don't plan on doing that, Judge. If
We have a judge, we have a juror who's in a little bit of distress.
Would you like a bottle of water?
So you had previously testified that around 3 p.m. was when you had gone to Mr. Gutierrez's apartment, correct?
Sounds about right.
So the Facebook post would have been made anytime from 3 p.m. later into the evening.
Objection. He doesn't know what time.
This is my last question. He stated, Judge.
I understand what he stated, and go ahead. For the last question, go ahead.
I don't remember when I made the post.
Sorry, that wasn't my question. My question was that the post would have had to have been made sometime after 3 p.m. I'm not asking for a specific time, just that it was posted after 3 p.m.
Objection. He said on direct, I got there at sometime around 3 p.m. So to
Is there
say
an objection?
Well,
Yes.
wait a minute. What was stated on direct is not conclusive as to what she can ask on the cross.
Understood. No.
Okay.
But she's indicating it had to have happened after 3 when he previously on direct said sometime around then. That doesn't
But
define.
he can either say you're correct, or he can say no, or he can say I don't understand your question.
But previously he said I don't remember the time. Yes. Thank you.
I don't remember if it was before or after going to Junior's house.
But you made the post about your friend missing, correct?
Right, so it was after, obviously.
Okay, so if it was after, obviously, and you say you're at Mr. Gutierrez's house at around 3, it would have had to have been sometime, we don't know what time.
You know what? That's argumentative.
Okay, Judge, I'll move on.
Well, you've got the evidence, and now you're arguing with the witness to extract something that for argumentative purposes. I don't want to argue about it.
You testified on direct examination that you had returned back to Mr. Anderson's home? That you went to Mr. Anderson's home, you went to Sadie Beecham's home, then you went back to Mr. Anderson's
We
home?
drove past.
Okay, and you said that that was on your way home?
Yeah,
So where did Miss Beecham live, to your understanding?
I don't know. GPS, I'm not familiar with the area. So I couldn't tell you northwest, east, none of that.
Okay, yeah, and you said you used your GPS
Yes,
on your phone?
probably yes,
So your phone record should show you in those locations?
should.
Okay. Do you remember sometime around May 19th, 2020, having items in a trailer attached to your truck that were going to be disposed of?
Yeah, I do flooring, so, you know, there's always a lot of stuff to get rid of.
And did you ever have an inquiry from, I'd asked you about Mr. Hunt before, Mr. Hunt, John Hunt, asking if he could have a carpet that was in the back of your trailer?
Objection. That's hearsay. What Mr. Hunt said would be hearsay.
Well, the statement, can I have a carpet, which is in your trailer, to the extent that it suggests there was a carpet in the trailer, that hearsay-ish. The inquiry, can I have it, is not an assertion. Rephrase your question.
Did you have around May 19th, 2020, a rolled up carpet in your trailer?
I'm sure, yeah.
And do you remember a time where John Hunt asked you if he could have that carpet?
I don't remember what time it was that he had asked me, but I told him no, because the houses that we worked on were obviously terrible, so why would he want carpet that was probably saturated in dog urine? So, yeah, I told him no, he can't have it.
Do you remember what date that interaction occurred?
No.
And do you remember telling Mr. Hunt that you were going to be taking it to the dump?
What else would I do with it?
Well, I'm asking you.
You can just answer the question.
Yeah, of course took it to the dump.
Okay, and did you take it to Pheasant Run?
No.
Didn't you tell Mr. Hunt that you were going to take it to Pheasant Run?
I told him I was taking it to the dump.
And do you remember talking with law enforcement in this case?
Yeah.
More recently?
We,
Within like the last 2 months, do you remember speaking with law enforcement about this case?
well, yeah.
And do you remember telling them that you had taken that to Pheasant Run Hill landfill?
I went to Pheasant Run one time, and it wasn't for that. It wasn't for, I was helping a buddy, and it wasn't for that. I always use the city dump
And where's the city dump?
on 50th Street.
And when had you gone there with the carpet?
I don't remember.
So May 17th, 2020, your phone pings at Mr. Gutierrez's apartment. May 19th, you're back at Mr. Gutierrez's apartment and then go to Mr. Anderson's, Miss Beecham's house. What were you doing on the 18th of May?
I don't know. I don't remember.
Were you working?
I don't know. What day was it? Saturday, Friday,
Monday, May 18th.
Monday? Probably working, maybe. I don't know. I'm not sure.
Where were you working around that time?
I'm not sure. I work all over the place. So I don't have a 9 to 5 where I go to the same place for work.
Do you remember texting your mother in the morning of Monday, May 18th, asking her if she could take you to 2 banks?
I'm sure. I have a good relationship with my mom. She's lived in my home.
Why would she need to take you to the banks, though, if you used her car on your own?
Maybe we were going to breakfast, lunch, I don't know.
And do you remember why you had to go to the banks on Monday, May 18th, 2020?
I have bills to pay, so probably depositing money or withdrawing money.
And so you'd have no reason to be in Illinois on Monday, May 18th, 2020, correct?
Objection, it's irrelevant. It's irrelevant whether he was in Illinois on the 18th.
What's the relevance?
It's relevant as I don't want to make the argument in the presence of the jury judge.
Well, if you work up to the inquiry, then perhaps the relevance will become apparent to me before. But I don't. I have suspicion that the jury is probably feels we've had quite enough times they've been excused. Ask a different question.
Were you working in Illinois on Monday, May 18th?
Possibility, yeah. It's a possibility.
Did you provide any records from your bank to law enforcement?
Objection, again, irrelevant.
Well, that question, go ahead.
I can if I need to.
No, her question was, did you do so?
Yes.
You handed them a copy of your bank records?
I showed him.
And did the detective ask to keep them or no?
Objection, sounds like it calls for hearsay, and
Did
it's
you
irrelevant. And it's irrelevant.
Did you?
It's not. It's not hearsay. I'm still in question as to the relevance. Go ahead.
Yes.
Did you keep them? Did you give them to the detective to keep?
No.
And you did not show those to me, correct?
To who?
To myself.
Objection, totally irrelevant.
And we're at the point where I guess I do need to have some idea what the relevance is.
as far as the information being provided in conversation to the state and not the defense, and nothing further being done with that information. Because remember, the state has opened the door as to what the defense could have done, and so this is about information that I was not given the opportunity to view.
Well, you can't testify.
We've
I
already.
understand that.
We've
All
already
right, we're going to
litigated.
break for lunch. Please don't talk about the case during the break. Don't read, watch, or listen to any account of the trial, and we'll see you at 1 p.m. Is that convenient? Thank you.
I release the horse raffle.
From Mr. Campbell to his mother, establishing his whereabouts on May 18th, that are contradictory to his GPS location data, which puts him in Illinois on Monday, May 18th, 2020. He claims in his text messages that he's here in Kenosha asking his mom to take him to the banks. That's the extent of the information that the defense has. The defense knows that about a month and a half ago, the state had Detective Correa meet with Michael Campbell. During that meeting, Mr. Campbell had, I guess, shown his bank statements to Detective Correa. Those were not maintained. I was not also shown them to be able to establish any sort of report to his testimony about him going to banks here, him not being in Illinois. Obviously.
Why is that? Why are they inconsistent?
Well, it's not that it's
here, right now, as we
Right.
sit here, we're what, 6 miles from the state of Illinois?
Sure, where he was in Illinois is actually 40 minutes away, Judge, according to his GPS location data. And it just goes to the fact that there's information that exists that was privy to the state that we were not, and it also goes to the investigation that the state had. And you know, the state's asking for the jury to find Mr. Campbell to be credible about why he went there, his reasons for going there, his thinking. Who knows how they're going to argue Mr. Campbell's testimony. I have a duty to my client, to Mr. Anderson, to impeach a witness's credibility where I believe that there's impeachable information. These bank records that were shown to the state could just be the linchpin in that. And also then it calls into question the police just believing everything that Michael Campbell had stated. That maybe if the investigation, they had done their job, they would have noted that Mr. Campbell was lying about his location whereabouts during the alleged time frame that Mr. Gutierrez's body is being disposed of.
Mr. Rivley?
So, Judge, we're looking at the location data right now. The defendant's phone pings at 10:09 a.m. in Illinois, 10:09.
Sorry, Michael Campbell's phone.
I'm sorry, Michael Campbell, sorry. And at 1:43 p.m., it pings in Kenosha. So he's in Kenosha from the afternoon hours on. It only pings 3 times.
I believe. But
So hold on. So literally, what counsel has just sewn together for you is based on occasional location data pings one of which in mid-morning is Illinois, then mid-afternoon he's in Kenosha. So again, there's nothing that is actually productive that is here. Now, if you recall, Judge, this is the actual person, Mr. Campbell, where the court has heard a Denny motion and made a ruling. And yet we're still having a jury hear cross-examination about each of the details that I thought the court, when it denied the Denny motion and said there was not sufficient because of the lack of a motive, was precluding that information from being brought in. So now we have a cross-examination about the calls to his mother to get to the bank. That was in their motion. That was one of the facts that they described. The question about his financial records, that was brought up in their motion. These are details. The issue of whether the carpet and his interaction with Mr. Hunt, all of those things were in that motion. We're in a position, Judge, where the court has made rulings in this case. It made rulings in a disqualification motion. It made a ruling. It's in CCAP. This is another situation where the court made a pretrial ruling. That's why we hold these pretrial rulings. And here we are with exactly the same cross-examination that pretrial ruling was supposed to prevent. I mean, that's why it's good practice to do it as they did. You know, I mean, if you recall, I applauded them for bringing that up at the time, because it allows us to have a trial where those issues are not repeated.
This is not being offered as Denny evidence, and the court's ruling was that you weren't precluding me from asking these questions about facts. There's a difference between asserting where an individual is or isn't, or what they were doing. These are facts and evidence. I'm not introducing this to point the finger. It's been clear from the very beginning. I
don't think that's been clear at all.
This is the ruling about.
We had a hearing on this, and I made a ruling, and you're examining on things, and I'm thinking, and I asked several times what the relevance was, and you were evasive in your responses, and they said, well, you need to build up to it so it becomes apparent, so I don't have to excuse the jury every 5 minutes.
Judge, I do not believe I was being evasive when I'm simply trying to impeach a witness and get out facts that are established where he was on these days. The state is asking about that, and I'm allowed to cross-examine on what he's stating. He also, for the vast majority of his answers to the defense, had noted that he can't remember when he was or why he was at Mr. Gutierrez's apartment on the 17th, or he doesn't remember where he was on the 18th, and he doesn't remember. So I'm allowed to explore that.
By asking when he went to the bank?
Again, that establishes...
And then you tell me, well, he couldn't have been in Wisconsin because his phone was pinging in Illinois. And by the way, would you like to know how many times my phone registers to Michigan? Which is, I don't know, how wide is the lake? 90 miles? That's commonplace along the shoreline. I think you're...
if I could continue, Judge.
Pardon me?
Sorry, if I could, I wasn't...
I didn't ask you to interrupt me. Explain the full relevance of this in a way that it has utility to the jury when I've already ruled that you're not allowed to use Denny-type evidence.
I'd like to go back to my conversation that I had with the court and the state yesterday, where on the record, I outlined all of these things that I'd be going into. Everything that I've talked about, I haven't brought up anything additional. And the state even said, I agree that this can be talked about. And the court said, okay. I have not gone into anything that yesterday I made that record, Judge. I wanted to give a preview of what I was going to ask, and the court allowed me to do so.
That's literally not true. I mean, you know, we were here just one day ago, Judge. I indicated I had no objection to discussions about what he did throughout the 17th, or what he did in terms of the meeting up with Rosalio about the 15th or the text about the money. I never indicated that I was not going to object to the 18th or, or Pheasant Run or any of that stuff, the John Hunt thing. I don't believe they brought that up in any detail. But again, I've never indicated that that was appropriate. I argued vociferously against this in the motion. I don't understand how this keeps happening. I don't understand how the court makes a ruling and then we are again litigating the same thing. We've done this numerous times, Judge.
So, Judge, if I could, perhaps we can get the tail end of yesterday's, because we did bring this up. She brought it up. Why don't we get...
You know, it's one thing to examine about where somebody was when the events are happening and that. It's another thing when you run it through the filter, it's all seems to be directed at the very point which I stated it could not be used for, which was to point the finger of suspicion at another person. We went through that, we had a hearing on it, and I said, no, it can't. But now the evidence seems to be headed in that very direction. And then, as I said, I'm hearing that, did I hear wrong? The representation made that his phone couldn't have been in Wisconsin because it was in Illinois, and they're telling me it certainly was.
I did not say that, Judge. I had asked him if his phone pinged
I
in
sure
Illinois.
formed the impression that you did.
I join in that impression. I invite us to listen to the argument that counsel made by having it read back at that point. There was no mention that the phone also pinged for large portions of the afternoon in Kenosha. That was not brought up to the court. So, you know, the court was asked to make a ruling about relevancy and whether Denny had been violated when, if counsel has a full knowledge of where that phone was and when it was pinged, which she seems to demonstrate situationally, then how could she believe it was appropriate in making that argument to not tell the court, well, in fact, it was pinging in Kenosha at 1:43, which would also allow access to banks, et cetera. Banks are open during that period of time on a Monday. So, again, Judge, it is not a situation that I am familiar with exactly what the litigation strategy is here to return to these issues when the court has made rulings. And the representation by counsel just now is incorrect.
Which, the representation that we talked about this yesterday, we did. Perhaps we can get, you know, the transcript from the end of the day and compare that. But in any event...
No, you're not, because we've been in constant session today. We've been constant argument since 9 o'clock this morning. The reporter does get to have a little bit of a break. This is, but I'm comfortable with what we've talked about in this case, and I'm not saying you can't get a transcript, but
It would just be helpful, I thought, for us, for the court actually, but everything she asked about was directly in relation to what the state elicited on direct.
What's your point?
The point, Judge, goes to credibility of this witness. He's asserting he's someplace...
Well, are you impeaching on a collateral matter? An extrinsic matter?
No.
So, Judge, I agreed to withdraw a mistrial motion. I did that based on assurances that the court was given on the record that we would not be inquiring about these areas before. We didn't bring up the specifics of the Campbell part of this because that had been previously ruled on. It didn't even occur to me that I would have to explore with the defense or to have it put on the record in the court that prior court motion that the court ruled on would have to also be additionally included again. But, you know, the defense made assurances to us which allowed the state to tell the court I was withdrawing a motion and asking to proceed. And now, from the state's perspective, the questioning regarding the contractor issues with Daniel Spear, along with the attached argument made in front of the jury, and now, even more egregiously, the situation involving Mr. Campbell, are a direct violation of the assurances this court was given. Several days ago, when I walked in here with a stipulation to provide the court to allow us to proceed. So I'm at wit's end. I guess I'd like a little time to think about, from my perspective, where we're at here, and I'm sure the court is doing the same. But at this point, we are not in a situation where the other side is complying with the assurances they've given or court orders.
All of the questions,
Or court
Judge,
orders.
all of the questions were perfectly in line with directly contradicting what this witness said on direct. And so perhaps the state is at their wits' end about this, but it also seems like the second or third time that they've walked up to the mistrial line, or at least threatening to, for reasons unknown to the defense. But there was nothing improper about any of these questions. There was no violation of the Denny motion, or the Denny ruling, and we made it clear to the court when you ruled on that, and that was fine, you made your ruling, but we made it clear we were still pursuing, lack of investigation. And this is even beyond that, though. This is direct contradictions from his direct testimony. So that was all that was being elicited here.
So I asked no questions about carpet. I asked no questions about meeting with John Hunt. I asked no questions about dumping materials at dumps. I don't believe I asked any questions about his whereabouts on the 18th. So I believe that those areas were not covered by the direct. So again, counsel has just represented to the court that they've asked no questions on cross that were not covered on direct. And I've just given the court multiple examples of how that is a categorically false statement offered to the court. It's simply untrue.
Okay. So, Judge, this was all covered yesterday when we told the court and counsel exactly what we were getting into with Mr. Campbell. So there's no surprise here. I don't know what all this discussion about being surprised is, but there's no surprise. So if the court wants us to move on, that's fine. We'll move on.
And of course the solution is to move on because the rule has been broken. Counsel, interestingly,
okay, that's just not accurate.
Don't interrupt.
Okay, I apologize.
Abandons the first argument when I provide examples of how that first argument is not correct, and then returns to an argument it's made multiple times already to the court. And I again deny that argument as well. But I don't want to repeat it again and again and again, because yesterday when this was previewed, I in no way indicated I was supportive or agreeable to any information about dumping or any information about the 18th. I continue to indicate what happened on the 17th is relevant. I continue to say that, and I did yesterday. But this is Denny, and again, it's a violation, and the court is not even hearing correct argument from the opposition.
It's my impression that it's in the Denny area, and it was precluded by my prior ruling. So I'm not going to tell you what to do, but I will tell you that there have been rare occasions when lawyers have flagrantly flouted one of the court's orders, and the most common example is an attorney who would ask a question, I'd sustain the objection, she'd ask it again, and I sustained the objection, and she asked it again. And I said, did you hear what I said? And she said, well, she just glared at me. So I excused the witness. We don't want that.
No,
But it didn't happen.
And in no way am I trying to
I don't want to. I think we've exhausted the subject. The record's what the record is. If I'm misinterpreting what happened, then I've made a mistake. But it is my impression that this area has been precluded by the pretrial ruling. Come back, please. What did I tell the jury? 1 o'clock? All right. Thank you.
When would you like us back?
1.
Good. I did have just one question, and and this is just to prevent us from having the jury come back or have to leave at any point. So defense on cross so far of Mr. Campbell has asked the question of Mr. Campbell, did you assume that he had something to do with your friend's disappearance? The answer was something like, you bet, or something like that. And then the next follow-up question was, drove over an hour just to have a conversation with him? And his answer was, yes, I did. So I'm aware of the court's ruling on the hearsay. I'm just asking the court, and I don't want to make additional argument. I'm just indicating, does the court feel that that has opened the door in any way that allows admissibility of the things we talked about this morning? No argument.
That allows the
admissibility of the thing that I sought to introduce this morning. So in other words, did the fact that the defense asked those 2 specific questions cause any change in the court's hearsay ruling from this morning? And I'm not asking to be able to extensively argue it. I just know that that additional thing has happened. So that he was directly asked those questions. And so whether that changes the ruling on admission of hearsay on that topic is my only question.
Well, I'm actually going to invite comment on it.
Oh, no.
Did you want to respond?
Yes, thank you. The questions about the nature of why Mr. Campbell testified that it was simply just to go there, have a conversation with the guy. Those questions were offered to try to rebut his answer about that it was going to be a civil conversation. That's all the defense has to add, Judge.
Why?
The reason for him going there, which I believe was also addressed by the state, but his assertion was that it was just to have a conversation. My asking those questions was to show how to discredit his answers about his nature of him going.
And so my argument there is, yep, that they've now attempted to discredit an answer he was legally precluded from giving, right? So the court made a ruling, and now the response from the defense was to make it seem as if he failed to provide an answer and so is suspicious. So remember, I was only allowed to argue or to ask him a question where I said, well, did you go to a particular place? Yes. Whose place, right? And then he got the name. Now, defense has responded to that direct, where I was limited, and they said, did you assume he had something to do with your friend's disappearance, and you drove over an hour just to have a conversation with him? And of course, that's the direct allegation that they made in opening as well. And so now, again, the jury is left with this, that all that has been offered in direct is that he went there with no explanation why, and now there's been some assertions under cross that there is a aspersion, there's a reason that's dishonest in some way, right? And so now his credibility has been directly challenged when the actual honest answer is that he's legally precluded from offering the answer that would settle that issue, or would at least illuminate that issue.
My understanding in direct, though, is that he had said that he was going to Zachariah Anderson's house, and then he said that the reason he went there was to talk to him about his friend's disappearance. So the defense then asking, you drove an hour out of your way to talk to someone that you thought had something to do with your friend's disappearance, is not anything new that I opened the door to. Rather, it was just calling into question his previous answers.
It's the 2 questions in sequence is my argument to the court.
But there was nothing that didn't come up in direct. I didn't offer any new information, nor did the witness offer anything that I feel leaves the jury at a cliff.
Well, it's closer, but I'm going to leave it as it is. All right. Ready to go?
Yes.
Yes.
Would you come down, please?
Okay.
Petition to correct.
The defense has no further questions, subject to recross.
State.
We have no further questions.
Mr. Campbell, you're free
You
to
guys
go.
step down, sir.
He's shocked he can finally leave.
Raise your right hand, please. Do solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated. Oh, that's it.
Ms. Saylor, can you state your first and last name and spell both your names for the... I'm sorry, did we swear in? I apologize.
I did?
Oh, okay, sorry. Can we state your first and last name and spell both your names for the record?
Erica Saylor, Erika Saylor.
And Ms. Saylor, what town or city do you live in currently?
Kenosha.
And do you have any children?
I do.
How many?
3.
And do you have any children with a person named Michael Campbell?
I do.
How many?
2.
And as to Michael Campbell, were you back in May of 2020 in a relationship of some kind with Mr. Campbell?
Yes.
How would you characterize the relationship in May of 2020?
He was my boyfriend.
And where, if any place, can you tell me, did you reside versus where he resided in May of 2020?
We lived together.
And again, what city was that in, if you can tell us?
Kenosha.
Ms. Saylor, Are you familiar with a person named Rosalio Gutierrez?
I am.
And how do you know that person?
He was a friend of mine.
And when did you first know him?
I met him about 16 years ago.
Okay. And has he been was he a continuous friend up through May of 2020, or was he a person you knew periodically?
No, he was a continuous friend.
Okay. And what, if anything, can you say about in the time period of May of 2020, whether he and Michael Campbell had any connections or were in any way attached, friendship, work, any of those things?
Both. They were really good friends, and they worked with each other quite often.
Now, I've indicated Michael Campbell. Is that a person you're in a romantic relationship of any kind today?
No.
Okay. I want to turn your attention to the weekend that happened just before May 19th. Well, let's start with May 19th. Apologize. On May 19th, a Tuesday of 2020, was there a moment that somebody brought you news which was worrisome to you?
Yes.
And what would be your best estimate, again, just an estimate, on what time you received that news and where you were?
I would say it was probably early afternoon. I was at home.
Okay. And who provided you news? I'm not asking what it was, but who provided it to you?
Mike.
And based on the news that you heard, did anyone else eventually arrive at your home?
Yes.
And who else do you recall arriving at your home, again, on that afternoon of May 19th, 2020?
Brandon Hendrickson.
Is that a person you already knew?
Yes.
How did you know that person?
He was a friend of ours.
Okay. And after both Michael Campbell and Mr. Hendrickson and yourself were at the residence, what, if anything, did you do to begin to investigate any matters?
I immediately began to look for information in regards to Sadie. I knew that she had been seeing Junior, and
Let me stop you. So when you say Junior, are you referring to a person we've identified previously as Rosalio Gutierrez?
yes,
So if you say Junior, that's who you mean?
yes.
Go ahead.
I began to look for information to find out who Sadie was.
Were you ultimately able to figure that out?
Yes.
And if you recall, what source did you use? If you don't, just indicate in general.
Oh, yeah. I searched Junior's Facebook friends.
Okay. And ultimately, you found an individual you could identify as a person you believed was likely Sadie?
Correct.
Okay. And then at that point, did you have a name for that individual? If you know. Did you have other than Sadie's first name, did you have a
No, I only knew of her first name.
Okay. And then what further investigation, if anything, did you do after you received or after you found out that who Sadie was?
I dug through her Facebook, just trying to get some general information about her ex. And then after that, I C-capped her.
Okay. And did you figure out who the ex was?
I did.
And were you able to get a name?
Yes, I was.
And what name were you able to obtain?
Zachariah Anderson.
And in general, are you aware of what sources or how you figured out that her ex was Zachariah Anderson at this point?
Yes, so when I C-capped her, there was, I think, a few court cases.
Yeah, okay, I don't want to know the details, but that you did through CCAP? Mm-hmm. Okay. And ultimately, through CCAP, you were able to identify a name, and that's Zachariah Anderson?
Correct.
And at any point, did you do any further investigation regarding this person, Zachariah Anderson, in relation to where the person might live or any of those kind of things?
I wouldn't say that I did further investigation into where he lived because that information was in the public records that I found.
Okay. So at some point, did you have in your possession on the afternoon of May 19th, 2020, an address you thought was likely an address of Zachariah Anderson?
Yes.
And what did you do with that information? Did you give it to anyone? Did you just keep it a secret? What did you do?
I gave it to Mike.
And that's the person, Michael Campbell?
Correct.
And I don't want to know what was discussed, but after Michael Campbell received it, what did you observe happen next?
He left the house.
And did Michael Campbell leave with anyone?
Yes, with Brandon.
Okay. was anyone else who are adults present when Michael Campbell and Brandon left your home?
No.
And what would be your estimate, if you have one, on what time they would have left your house? Again, only if you know.
I would say late afternoon.
Okay. Excuse me. Ms. Saylor, I'm going to now turn your attention to the weekend before this Tuesday the 19th. Okay? What, if anything, can you say about any memory you believe you have about contact with Rosalio Gutierrez on that day? On that weekend, I apologize.
We spent time with him that weekend at our home.
Do you have a recollection of what day that would have been? Only if you know.
No, I can't say exactly.
And do you have a recollection of who else was at the home with the three of you?
Our children.
Okay, meaning your children?
Correct.
And are you, other than your children and Rosalio Gutierrez and yourself, who else was present, if anyone?
Mike.
Mike? Mm-hmm. Okay, and were any other children present other than your children, your grouping of children?
I believe his children were there, but I honestly don't recall.
Okay. And do you recall what was going on in this situation?
Oh yeah, we were just having dinner like we would do weekly.
All right. Now, I'm going to turn your attention now to the Sunday evening, May 17th of 2020. In the evening hours, so dinner on, do you believe you recall who you were with, if anyone?
Yes.
And who do you believe you were with?
I was with Mike, my kids.
Mike Campbell?
Correct.
Okay, and kids meaning the three kids you mentioned?
Yes.
And where were you located?
And our home.
Okay. And were you able to look back through either your social media or your phone, any information you keep on your phone, or any information you store to provide some information to you about what was happening around mealtime?
Yes.
And did you provide that eventually to the DA's office?
I did.
Okay, I'm going to show you a video. What? Oh, let's do that.
On State's Exhibit.
Ask you if you recognize this as something you provided to the state, meaning the DA's office.
I'm going to object as far as relevancy and foundation.
Respond.
Yes.
She's indicated who was with her on the evening of the 17th. She's indicating she has a memory of that. She's indicating these videos contribute to her ability to remember that. So we're going to show these as to confirm that she's bolstered by the fact that she has reviewed these videos.
But she is what?
She's bolstered by the fact that she has found these videos and that they confirm her memory that she and Michael and her children were together.
I'm not clear. Are you asking her to view them to refresh her memory, or merely to buttress the fact that her memory has been refreshed?
To show that they confirm the memory of what she remembers that day. So they bolster her memory, correct? They bolster...
So are you offering for her to look at them, or the jury to see them?
I'm offering them for the jury to see, because they are the reference points that allow her to say, yes, on the 17th, this is what we were doing.
Yeah, Judge. She hasn't established that her memory is faulty in any way, so this isn't being done to refresh recollection that she's indicating she can't remember. And you can't bolster someone's memory of what happened before. I mean, first of all, we're not supposed to bolster anything, right? But also, if it hasn't been established that she needs this to refresh anything about what she's testifying to, it's really not relevant.
If it were, and I'm still not clear.
Okay.
If it is being done to refresh her recollection,
It is not.
okay. Well, you can't refresh her, you can bolster her credibility, but only after it's been attacked.
So,
I'd ask that the image of the video be taken off the screen.
so here would be the example I would liken. If somebody says to you, okay, on this day, where were you? And you go through your social media and you say, I have reviewed my social media, here's how I know where I was on this day and what I did on this day. Then I believe you can not only testify, here's where I was and what I did on this day, but you can say, here are the ways that I have been able to determine that. Otherwise, as the court can imagine,
how is it different from a witness who has a memory of something and then offers a document to substantiate the accuracy of the statement?
That's prior.
Prior consistent statement, if there's...
No, it's not a statement.
Well, no, that's the prior recorded, it's prior recollection refreshed through the document itself.
Because she says the memory doesn't require refreshment.
Judge, I think the objection that I had noted too was, I think we haven't gotten to that next step of whether she needs refreshing her recollection or if we're admitting the video as a past memory recorded.
No, that's...
But I think what my objection was to foundation as well, because the state hadn't asked her about where she was that evening and then just attempted to just show the video.
The rules we've been talking about, and maybe I was the architect of the problem, deal with principally with statements. It doesn't have to be statements. It can be other things that are used in one instance to refresh recollection, which has been testified to be exhausted, or as a record of a past recollection. But there are also situations, I had dinner at the house of Gerhardt the other night. Here's the receipt. That doesn't fall into either category.
No, I think that would be permissible. That hasn't been done here.
Well,
the previous question is, that's why I had objected to foundation.
So again, the questions that have already been asked, okay, so the record is already in. I asked her where she was that day, who she was with.
Right.
And that evening. Now I'm asking whether this video is hers, and did she use this to be able to determine where she was, what was going on that day. So it is her, essentially what you just said. It's her saying, because I'm looking through my social media, I'm able to recreate this. Just as if you had a receipt, you'd be able to recreate it.
The normal and most direct way of asking those questions is to ask her what she was doing if she remembers. And then if she has trouble remembering, then this may come into play. But there hasn't been any showing of relevance other than to want to play it in front of the jury. And that's a separate issue, by the way, as to whether or not it's something that is relevant to a finding of fact that the jury would have to make here.
Well, unlike you, as I've said before, I haven't seen any of this before, so I have no idea. But if he's describing it properly, then it's a refreshment of recollection through a past recorded recollection, which is a kind of a hybrid. But I think it's admissible, just like my dinner receipt would be.
Okay. All right. And Judge, I'm just going to request that that you limit each of our counsel tables to only having one attorney per witness render objections or make arguments. So I just fear we'll never get out of here if you allow both attorneys on either side or all three attorneys. We have 5 attorneys. I just would ask the court to make a simple request or perhaps an order indicating anytime there's going to be argument here on a particular witness, that one objects and one makes the legal rulings, and that we not go back and forth.
Well, I understand the time issue, but this is something that the rule exists principally for the protection of the poor reporter, and she's indicated thus far anyway it hasn't presented too much of a problem.
Okay.
So I'll leave it as is.
All right. Again, Ms. Saylor, were you able to determine many things about the evening of May 17th based on a review of some information you had in your possession?
Yes.
And particularly, were there two videos that caused you to have some memories that allowed you to recreate May 17th in the evening hours?
Yes.
All right. And did you provide those two videos that helped you recreate that knowledge of what happened on that evening with your family?
I did.
Okay. So now I'm going to show you again, and I've lost track of what it was marked.
State Exhibit 1, number 346.
State Exhibit 1, number 346, and ask you, is this one of the videos that you observed that allowed you to have a memory of how the evening went on May 17th? It's going to come up in a second. Okay, so is that taking you? Is that you taking a video there
That is me.
of you essentially panning the food?
That's right.
Panning across the food. Okay. Does this refresh your memory about what you guys ordered for food that night?
Yes.
Okay, and what was that?
Shogun.
Okay, and were you able then to show us a time and date stamp on a separate document that verified that this video was from the 17th in the evening?
Yes.
So now I'm going to show you that, and counsel, if you'd say what that exhibit is numbered.
State Exhibit 1, number 347.
Okay, so is this again the video in question?
Yes, it is.
Okay, and can you see on there some sort of a time stamping that allows us to tell you what date and time that video was taken?
Yes.
And so what does this exhibit reveal?
It states May 17th, 2020 at 7:30 p.m.
Okay, and is that consistent in your memory with when this food was served to your family?
Yes.
Okay. Now, do you also have a memory from the 17th of a performance taking place at your household?
Yes.
Okay, and I don't want to know the name of that individual, but can you indicate by sex and age who that person was back in May of 2020?
A male boy. Is that what you want?
Well,
you said
son
by
or
sex
daughter,
and age.
son or daughter.
Okay,
yeah.
it was.
We're trying not to say names of minors out
Gotcha.
loud.
Yeah, no, definitely not. It was my son.
Okay, and what age was he in the video?
He was 7. 7.
7?
7
okay.
or 8.
And did that also provide you some context of this particular Sunday at your house?
Yes.
Okay. I'm going to ask you to take a look at that, and it's marked what?
States Exhibit 1, 345.
And then tell me, as this is going on, is there a person peeking sort of in the background?
Yes.
Okay. Now, are you the one providing whatever the commentary is there?
That is me.
Okay. And did a person peek through a doorway in the background there?
Yes.
Okay. And who was that individual?
That was Mike Campbell.
And is the hairdo that we saw in that peek the same hairdo you recall him having on May 17th of 2020?
Yes.
So as I saw him, he appeared to have a shaven head.
That's correct.
Okay. Is that the hairdo that he had throughout May of 2020, or did you observe him to change his hairdo at any point during that period of time?
No, that's the hairdo he's had as long as I've known him.
I have no further questions, Your Honor.
Question 7.
Good afternoon. that last video we saw, you didn't have a timestamp on that one?
I don't, I mean, there is one. I don't know that I provided that.
Okay, and then the video of the sushi, had you gone out to eat?
No,
Okay, that was at home.
correct.
Okay, and then the state had said you had provided that to the district attorney's office?
Correct.
That was just recently, correct?
I would say, gosh, to be honest with you, I don't recall when I sent that to them. It may have been last year. I don't really remember. It may have been earlier this year. I don't recall exactly.
But it wasn't in May of 2020?
No.
You didn't speak to detectives in May of 2020?
No, I did not.
No one ever reached out to you?
No.
Okay. May 17th in the early morning hours, like 1 to 2 a.m., do you remember where you were then?
I believe I was at home.
Sleeping?
Could have been.
Yeah.
Yeah.
Early. Do you remember, okay, so that would have been like really early morning Sunday, that Saturday. Do you remember what you had done on that Saturday, May 16th?
No.
Okay. You have no recollection of going to a bar or anything like that?
No, not that I can recall.
And in these videos we were shown about around 7:30ish on May 17th, 2020, you said Mr. Campbell was with you during those times?
That is correct.
Do you know did you have any information or did you make any observations of where Mr. Campbell was the very early morning hours of May 17th around 1 to 2 a.m.?
No.
And the very late night hours of May 17th, 2020, do you have any information of where he was?
I'm going to object as to vagueness, so May 17th at what time would be my request? Rather than saying very late hours.
That's for your request. Overruled.
You can answer it, sorry.
Okay. Please repeat the question.
Sure, the very late hours of May 17th, so midnight, early morning hours, 1 a.m., so of May 18th.
Mm-hmm.
Did you observe where Mr. Campbell was?
No.
No further questions.
So you had the sushi on the evening hours of the 17th, correct?
Correct.
Did Michael Campbell leave your home after you had the sushi on that day, on that evening?
No.
Okay.
No, he did not. I think I misunderstood your date. Sorry.
Now that you understand the question, does that, 11 p.m. on the 17th, the same night you had the sushi, where, do you know where Michael Campbell was?
Yes, he was at home.
Okay. Midnight on the same night you had the sushi, do you know where he was then?
Yes, he was at home.
Okay. Nothing else.
I'm going to make just a limited recross. Were you sleeping during those hours?
Could have been. I'm not sure.
So based on just what your observations are, you cannot definitively state during all those hours from, let's say, 12 a.m. or let's say 11 p.m. on the 17th all the way through, let's say, 6 a.m. on Monday, May 18th, you didn't make any actual observations if you were sleeping?
I'm a really light sleeper, so we were home in bed. If he would have left, I would have woken up from that. So.
No further questions.
Nothing on that.
You may step down, ma'am.
Thank you.
Just a second. So it's with Tucky, that's crime. Calls Ronald Watucky to the stand.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated.
Mr. Watucky, can you state your first and last name and spell your last name for the record?
Ronald G. Witucky, Witucki.
And how are you employed?
I work at the State Crime Laboratory in Milwaukee.
How long have you been so employed?
A little over 35 years.
And what's the nature of your employment at the Wisconsin State Crime Lab in Milwaukee?
I work in the DNA analysis unit.
How long have you worked in the DNA analysis unit at that agency?
When I started at the crime lab, like I said, about 35 years ago, we did not have a DNA analysis unit. We initiated the DNA analysis unit in the mid-1990s, so I was part of the unit before then, but I've always been a part of the analysis unit, the DNA analysis unit.
So, in summary, how many years have you been a person analyzing DNA samples in conjunction with the Wisconsin State Crime Lab? Starting when?
Oh, probably about 30 years.
And what sort of, first of all, education do you have to be able to get that position?
In 1982, I graduated with a Bachelor of Science degree in medical technology. I worked about 4 years in the clinical laboratory as a medical technologist. At that point, I went back to school and later received my biology major. I began work at the crime lab in Milwaukee in January of 1988, and I began a 6-month training program in forensic serology. In October of 1988, I attended a 2-week training session excuse me, on semen identification techniques at the Serological Research Institute in Richmond, California. In November of 1990, I attended a 4-week training session on DNA typing methods at the FBI Academy in Quantico, Virginia. And as I said, in the mid-1990s, I was part of the validation work that allowed us to implement the DNA typing technology into the crime laboratory and apply it to our casework. I took graduate coursework in 1997 in human development, anatomy, and biochemistry. I attended a 1-week training session on PCR DNA typing methods.
If I could interrupt, so, and have you continued, without needing to detail each one, have you continued to stay current in the field and continued to educate yourself and get trainings consistent with your profession?
Yes. Each year we're required to take 8 hours of continuing education on a DNA-related topic, and I've also done that.
And in your capacity as a DNA analyst at the State Crime Lab, during that those several years as a DNA analyst, do you have an estimate on how many samples that you have performed tests on to determine whether DNA was present?
Well, I never keep a running total or track of it, but it would have to be thousands at this point in time.
And did you test some samples and prepare a report dated August 8th, 2022 under a case name Rosalio Gutierrez?
Yes, I did.
And is that a case name at the lab that originally had a different DNA analysis or analyst do some work on that case as well?
Yes, that's correct.
Okay, so you were a second analyst brought in to do some additional testing, would be my understanding, is that correct?
I think that's a fair statement, yes.
And in the conjunction with the items you tested for possible DNA, did you prepare a report, again, dated August 8th, 2022?
I did.
And did you provide some conclusions within that report about the things you tested?
Yes, I did.
And do the opinions you offer that in report, and in fact the opinions you offer in your testimony today, are you offering those to a reasonable degree of scientific certainty?
Yes.
I'm going to show you what's been marked as State's Exhibit 44. Just for purposes of the record, could you indicate, is this a copy of that report of August 8th, 2022 that we've talked about so far?
Yes, it appears to be an accurate copy of the report that I prepared and issued on August 8th of 2022.
So you anticipated my next question, which is it a true and accurate copy of the report you prepared?
Yes, it is.
Any changes or alterations you see other than a sticker on it that has a number?
No, correct.
Judge, I'd move admission of the exhibit.
Is there objection?
No.
Received.
I'd like to go through your conclusions on that exhibit briefly. Ask, did you take a look at an item that is described as item AU, a piece of clothing described as jeans?
Yes.
And was that something that you were asked to determine whether there was the presence of blood?
Yes, it was.
And were you able to figure out whether the presence of blood were located on that pair of jeans?
I looked for blood. I could not identify any blood on those pair of jeans.
And were you able to identify DNA on those jeans?
There were a couple of stained areas that I extracted for DNA, and I did find DNA in both those stains.
And ultimately, were you able to compare that to a profile of a particular individual?
I compared it to several profiles. There was one matching profile for for the jeans. I compared it to several individuals, but none of those were matches. They were all exclusions.
So as to the match, was that an individual identified to you as Zachariah Anderson?
Yes. With my testing, I assumed since that was the individual associated with the genes or that they were taken from, that his DNA would have been present on there.
And in your lab world, when you say associated with and you're talking about genes, you mean who wore them? Would that be our normal phrase for that?
Yes.
Okay. So you would anticipate the person who wore them would have DNA on them. Is that right?
Correct.
Okay. And did you confirm that was the case in your results here?
When I looked at the profile, it was a mixture. And the types that I found, the types that were present were consistent with the person that they were from, Zachariah, but also there was another person, and when I tried to figure out who the other person was in that mixture, all the standards that I compared it to, they were all exclusions. In other words, no one explained who the second contributor was.
And just for purposes of the jury knowing, one of the people that you looked at who were excluded, meaning they were not the source of that DNA, was the individual Rosalio Gutierrez. Is that correct? So his DNA was not detectable on the genes.
That's correct. He was an exclusion as being the second contributor for that stain.
So to this point in time, the second contributor is unknown to you. Is that right?
That's correct.
Okay. Now I'd like to go on to an item that you identify as item AV, and that's labeled in your report as swabbing recovered from the exterior door north side. Did you conduct a test on item AV?
Yes, I was able to determine that there was blood present on item AV.
And was blood present?
Yes.
And then did you attempt to indicate whether that DNA had blood that was appropriate for comparison with the DNA of the other persons that you had samples of?
Yes, I compared it to several individuals, and there was only one person that came back as a match.
And does that mean that person would be the source for purposes of your discussion?
In my opinion, they were the source of that profile.
And who was that individual who was the source?
That was Rosalio Gutierrez.
Okay. And again, that was blood, and it was the exterior door north side. Is that correct?
Correct.
Based on the label? Okay.
Correct. That's item AV.
I'm going to show you this been marked as State's Exhibit 86, and just confirm that that packaging appears to be the same sample that you tested and, again, found to be the blood of Rosalio Gutierrez.
86? 86, yeah. Was it previously admitted?
Yes, it is. It has our laboratory case number, it has the item designation letter, and it also has the date and my initials on it.
So that is the sample that you've just testified to in terms of results.
Correct.
Okay. Now I'm at item AW that is indicated as a swabbing recovered from the interior door. Did you take a look at AW?
I did.
And first of all, did you try to determine whether there was blood?
Correct.
And how did you, what if any result did you get?
Again, I was able to determine that there was blood on that item.
And then did you do further testing to see if it was appropriate to see if anybody's DNA matched?
Yes, I was able to do, again, DNA typing on there, developed a profile that was usable for comparison and compared it to a number of individuals.
And did it result in a match?
Yes.
And who was the match?
Again, there was only one match, and and that person that it was matching to was Rosalio Gutierrez.
Now, when something is blood like that, is the single match idea? Is that what you would expect to have be the result?
You mean like a single source profile, or?
Yeah, as opposed to skin cells and those kind of things where there might be more mingling. Is blood a logical place for you to get a single source profile?
Probably that would be the tissue that yields a single source profile the most often for the cases that we work.
So no surprise that you got single source on blood?
No.
Okay. I'm going to show you then what's been marked as State's Exhibit 84. Ask you, is that the packaging for AW that you just testified
to? Yes, it is. And again, this has our laboratory case number, the item designation letter, which is AW. And I've also placed the date and my initials on this item.
Then as to item AX, which is described as swabbing recovered from the middle seat cushion of sofa. Did you conduct testing on that first to determine whether it was blood?
I did.
And what, if anything, can you say about a result in terms of determining its blood?
Once again, that was positive for blood.
And then were you able to compare the known standards and see if you could find a match in terms of DNA?
Yes. Again, I did a comparison to several profiles.
And were you able to get a match?
I did.
Who was your match?
Again, the match came to Rosalio Gutierrez, and the other profiles were not matches.
That was, again, a single source?
Correct. Well, that one actually gave a major profile, and there were a couple of markers that showed up very weakly. So I still came to the same conclusion as far as the major profile. There was those two additional markers that were some sort of very minor, trivial component.
Okay.
And that minor component was of such little information, it was not useful for comparison purposes.
Thank you. And so I'm going to show you what's been marked as State's Exhibit 83 and ask you, is this the packaging for what you described as sample lab lettering AX? And is that, in fact, the packaging for the sample you just testified to the results
of? It is, and again, it has all the markings that I described previously. It has our laboratory case number, our item designation letter, and then I've written my initials along with the date on the packaging.
So that, in fact, is the packaging for item that you've identified as AX, correct?
Correct.
Now I'm going to turn my attention to item AY. And that's labeled swabbing recovered from the living room ceiling. First, did you test that for blood?
Yes.
What was the result?
Again, I identified blood on those swabs.
Did you then test it for DNA?
I did.
What was the result?
Again, I developed a single source profile for those swabs, compared the profile to the profiles that I had for comparison, and they were all eliminations except one was a match, and that was from Rosalio Gutierrez.
And again, so this was blood, and it was the DNA of Rosalio Gutierrez?
Correct.
All right. I'm going to show you what's been marked as State's Exhibit 82 and ask you, is this the packaging for AY that you have just testified to?
Yes, it is. And again, it has all the markings I described before, the laboratory case number, the item sub-designation letter, and I've written my initials and the date on the packaging.
Now I'm going to turn your attention to item AZ, and Judge, there's only one other one after this, so this is the last of two. As to AZ, identified as swabbing recovered from the tabletop, did you first test that for blood?
I did.
And when you tested that for blood, what was the result?
Again, I was able to identify blood on those swabs.
And then did you attempt to see if you could match it in terms of DNA?
I did.
And what was the result of that attempt?
Again, I went through the same comparison. I have found only one match, and that match was with the profile from Rosalio Gutierrez.
I'm going to show you it's been marked as State's Exhibit 78. Ask you, is that packaging consistent with what you just testified to in terms of the sample utilized to make the determinations you just talked about?
Yes, it is. And again, it has all those markings of the lab case number, the item designation letter, and I've written my initials as well as the date on the packaging.
Finally, I'm going to ask you to take a look at item BA in terms of your report. Is that, first of all, identified as swabbing recovered from the kitchen counter? Did you test that for possible blood?
Yes, that's from the kitchen counter. I tested it for blood, and again, I identified blood on those swabs.
And were you able then to test that for DNA?
Yes.
And so whose DNA was that, if anyone's, that in terms of a match?
The profile, again, I compared to the profiles from different individuals. Again, all were exclusions except one matched, and that was from Rosalio Gutierrez.
So I'm going to ask you finally then to take a look at State's Exhibit 88 and ask you in terms of packaging, is this packaging consistent with item BA, the sample you just talked about the result?
Yes, it is. It has our laboratory case number, that item designation letter, BA, and I, again, have written my initials and the date on the packaging.
So I've showed you a number of packagings. Mr. Witucky, are you able, what if anything can you say about whether you're confident those packages are the same? I mean, you haven't opened any of them. So are you confident that those packages are the same items that you conducted the tests on that we are talking about, and why? Without opening them, how do you know that?
Well, first of all, when we look at an item of evidence, the laboratory case number with the item designation letter label is placed on that package. And immediately when I take control of the package, I place my initials with a pen and the date that I took control of it. And then when my testing is complete, I repackage the item, reseal it, and the tape that I use to reseal the paper packaging, I again place the date and my initials on the tape and the packaging, so that if there's any tampering, you'll be able to tell that someone had opened the package after I was done examining it.
So looking at each of the packagings individually that you examined, was that one of the things you were looking for, whether there was any manipulation or change in the packaging from what you would anticipate?
That's correct.
And so based on that, are you able to express confidence that each of the exhibits I showed you are in fact the actual items that you've testified to and written a report about?
I am confident.
Now, Mr. Wittucki, were you a peer reviewer on any of the reporting that was previously done by Lisa Treffinger on the same case?
Yes.
Okay, so I'm not going to go through the results with you, but when you peer review, what is it that you do at the crime lab to make sure that someone is accurate, or what's peer reviewing in the process that you were doing with Ms. Treffinger on the previous reports on the Rosalio Gutierrez case?
I guess I'm going to object as far as relevance, given that Lisa Treffinger's report's already been submitted into evidence without objection. I don't think it would be not relevant and cumulative to have him testify to Analyst Treffinger's report.
Well, I assume that at some point that there will be some disputing by the defense that Ms. Treffinger's conclusions in that report and regarding whether this item is blood, but also the details of the report may be challenged, and so this is the peer reviewer. So I wasn't going to ask each conclusion. I was just going to ask, what do you do to peer review, and did you have any issues with this report Ms. Treffinger did as her peer reviewer?
And
did he? I'm sorry. I apologize. I just took a breath. And did he review the same materials to check her conclusions?
And Judge, to that point, the test that would be in dispute that the state's referring to was not a test that was actually conducted by Lisa Treffinger. Item A1 was not tested for blood. It was just DNA. And so there is no blood test to be refuted. I think that her report that's been submitted, it's already been admitted into evidence, can speak for itself.
Are you saying there's no dispute and will be no dispute as to?
There's a dispute to her opinion, but it wasn't an opinion that was included in her report. So that opinion was not something that Analyst Wittucki, I apologize if I'm mispronouncing the name, peer reviewed, because it wasn't a test that was completed as to whether the presence of blood was existed.
The objections are ruled.
Okay. So, Mr. Wittucki, did you peer review the actual testing done by Ms. Treffinger in her report that I'll show you now, that is Exhibit 39?
Yes, this appears to be the copy that Lisa prepared, issued March 29th of 2021. And I was the peer reviewer, and I know that. Not only do I remember it, but my initials and date are on each of these 6 pages of the report.
When you peer review, are you aware of the entire process by which determinations are made or opinions are rendered by the crime lab? Or is it just the print in there, or is the entire decision-making process part of your peer review?
So what happens at the crime laboratory in any section, not just DNA, is that any report that is issued and is sent out of the crime laboratory has to be peer reviewed. And a qualified peer reviewer is a working case analyst that is knowledgeable and, as I said, qualified to do work in that discipline, in this case, DNA. So I was the reviewer in this case, and my job is to look at all of Lisa's notes, all the data she's collected, all her testing results, and then verify that her conclusions are based on scientific data, that they're sound, and that they're reasonable conclusions for the evidence or the data that she's collected and the answers that she's taken from those from the data.
So that involves you reviewing her notes?
Yes.
It involves you reviewing her actual results in terms of any chemical testing or DNA testing?
Correct.
In this case, did it involve you reviewing the photographs taken by the crime lab?
Lisa showed me the photographs of, well, not photographs. It was a photograph of, I believe, item A1A, which was a tiny dark spot that was collected from a van.
And was that part of your peer review of her findings?
Yes.
And were you aware in your peer review of a decision made based on any factor not to conduct any chemical testing to determine whether the item that they identified was blood? Were you aware that that decision was being made by the crime lab in this case?
I was aware of that decision, and I would say that any crime lab in the country would have probably taken the same path, that when you have such a small amount of material to work with, you don't want to risk losing the DNA evidence to trying some other tests that may use up all the sample or a good portion of it, that you don't get a result or a DNA result later on.
Involved in your peer review process, were you reviewing the judgment by Ms. Treffinger that the item identified on the van as A1 appeared to her to, by visual observation, be consistent?
I'm going to object. That is not an opinion in her report.
I indicated her overall assessment. If he peer reviewed,
I didn't hear you.
if he peer reviewed her her opinion that upon visual observation this item A1 was blood, did he peer review that?
What? Excuse me. Item A1 was what?
Was blood. Did he peer review that particular opinion offered by her or conclusion offered by her at the crime lab?
And again, that is not an opinion. That is not an opinion or conclusion that was included in her reports or any findings that I could note other than her testimony in this court. So I don't believe this analyst could have peer reviewed an opinion or a finding that was not documented.
Well, I believe he has.
Let him answer, and then you can cross-examine.
So, do you understand my question?
Could you state it again, please?
Sure. Is part of the peer review process that you have conducted in this case to render an independent judgment about whether the sample, A1, visually appeared to be blood by appearance?
I guess I'm going to object that that misstates the prior witness's testimony about how she came to her conclusion about that dot allegedly being blood. She didn't base that on the appearance. She based it on the other factors that I don't really want to go into much more.
Her first decision, her initial decision, was based on her visual observation, and as the court will recall, it's bolstered by her scientific results. So right now I'm asking, based on his visual observation, does he agree or disagree with her original conclusion, subject to further information?
Well, she's saying that's not what the evidence was.
I can ask him as an independent view, if you wish, what his independent observation is of it.
Well,
I believe I have fairly summarized her evidence. If I guess it's subject to cross if there's a disagreement.
Do you feel you're knowledgeable sufficiently to answer the question?
I can offer an opinion as to what the stain may or may not be. I don't, as was stated, Lisa didn't put in her report what her opinion was as to the source of the stain. But I can offer an opinion if that's the question.
Is the opinion that she offered to us in our courtroom, is that a decision that was discussed in peer review?
Judge, I'm going to object.
Can I finish?
No.
We don't know. He wasn't here for her testimony.
No.
Correct.
I believe this particular opinion is one he has peer reviewed. The opinion offered by her.
No. That's not what your question inquired. Your question was, is the opinion she gave here in this courtroom? And he wasn't here.
Absolutely.
Rephrase your question.
Yep. Did you peer review a decision by analyst Treffinger that the A1 appeared visually to be blood?
I wouldn't say I peer reviewed that. I would say that based on what I know and the appearance of the stain that Lisa was able to provide to me, that the proper decision was made that this had the appearance of possibly being blood, and that she forgoed the testing that might allow you to determine whether or not it was blood, with the hopes of gaining the DNA knowledge rather than risk losing the DNA and just saying, oh, this is blood, but now I don't have any DNA profile for comparison.
So based on peer review, you agreed with that call, with that decision?
I'm going to object. He didn't peer review that opinion, and he's already stated that he didn't make a peer review of that as it wasn't a finding in her report.
What?
He just offered his own opinion.
Well, is he a peer?
Sorry, what?
Is he a peer?
Yes.
Well, can he give a peer review right here in the courtroom?
He wasn't present for everything that she had mentioned, so no, because he wouldn't be able to make a decision based and testify based on what she provided, because that opinion she provided, Judge, the first time we heard that was in this courtroom. That was not documented anywhere. So it does not exist in any other form or fashion or any notes. So gravely attempting to go down this road would, sorry, Attorney Gravely, would not be appropriate given what's already been testified to and the fact that her opinion was only stated in court.
So, Judge, this is something the court has heard us talk about several times. It was talked about more than a year ago in public proceedings. It's been talked about numerous times. This is not new information. This conclusion that we're talking about is not a brand new conclusion to the defense. They've heard this, and the court has heard it several times. So,
what I'm most interested in is whether this witness believes himself to be qualified under scientific standards to conduct a peer review of what was reported in this case by Ms. Treffinger.
Yes, the answer to that question is yes.
And is that something you could do forthwith? Immediately?
Well, I peer reviewed all of Lisa's work on this case. So before the report goes out, the peer reviewer needs to agree with all of Lisa's conclusions that she's written down in the report. So I agree with everything that's in Lisa's report.
okay, so what we've said, though, is that what is not in Lisa's report is the additional opinion offered that the item tested, A1, appears consistent with blood evidence. based on scientific findings and observation. Are you able to offer a peer-reviewed opinion about that particular thing, knowing that's not specific in the report? Are you able to offer that peer review?
Yes.
Okay, so that is my question. What is your peer review conclusion, and what is it based on that would lead you to be able to render an opinion, yes or no, about whether you as a state crime analyst believe A1 appears to be blood?
So this stain A1, I asked Lisa if she could provide me a photograph of it, and she did, and she showed it to me, and it's a very, very small stain. And as I stated previously, this was absolutely the right call to not do any presumptive testing for blood and save this precious amount of sample, because it's very limited, and put it all into the DNA typing procedure, which is what happened. And she was able to develop a lot of information from this DNA profile. Now, the question is, what is the source of that DNA? So, with the typing procedure and the results that we obtained, we know that that tissue from A1 is human tissue, but we were not able to do any testing to determine what the source of that tissue is. However, this tiny little dark-colored speck or splash is not consistent with semen. It's not consistent with saliva. It could not be a hair. Could it be skin cells that are providing the DNA? And again, I would say no, for a couple of reasons. One is skin cells are what we call touch DNA that sloughs off your hands as you handle objects, is not a very good source of DNA. And while there wasn't a lot of DNA in this sample, it did yield a fairly, a relatively intense profile. Again, not real strong, but not really consistent with just incidental contact or touching. However, the most reasonable explanation, given the color and the appearance of this tiny little speck or splash, is that it's blood. And as I stated previously, the DNA testing shows it had to have been human tissue.
And is the photograph you're saying you reviewed a photograph that was essentially a photograph while this speck was still in a van?
Yes, that's my understanding.
Mike, are you looking for a copy of the photograph?
So I'm going to show you a picture and ask you, well, no, that's all right. So it was a picture of a speck, a crime lab picture taken of a speck in the interior of a van. Is that right?
That's my understanding, yes.
So I'm going to show you what's been marked as
315 on Exhibit 1. Exhibit
1, 315. It's going to come up here on the screen. Is that what we're speaking of?
It looks like the photograph Lisa showed me.
Okay, thank you. Now, again, the opinion you just described as sort of a peer reviewer of this item, are those opinions you offer to a reasonable degree of scientific certainty?
Yes, I would say in this case it's based more on my experience at the number of cases I've handled, I've screened, and I've worked over the years involving blood.
And you described this picture or this speck that you talked about as a splash. Why do you use that term, just so I know?
Well, it was so small, and you might, I guess, wonder how did it get there? To me, it had the appearance of.
I guess I'm going to stop, and this is asking for an expert opinion in the appearance of a stain, and I don't believe that, respectfully, that this witness's qualifications in that regard have been established.
You can cross, and if that develops, then I'll take a remedial measure. Go ahead.
Go ahead.
Based on the appearance of it, it looked to me like it was something that would have sprayed or splashed and landed there and then dried, that it wasn't some sort of application or brushed on or that type of thing.
When you say application or brushed on, what does application mean? Does that mean the same
I guess
thing?
I'm going to object again. This is going into now expert opinion on stain pattern analyses that hasn't been established if the state or given notice of as it relates to this witness. And if the only thing he observed was that particular photo, I think that's another issue.
I don't know that Mr. Gravely had finished his question.
I just wasn't sure what the word application means in the way he used it. That was.
Did you finish your question?
Yeah, that was my question. Yeah, what does application mean?
Okay. The objection's overruled.
Probably very similar. It didn't look to me as if there was any appearance that it had been brushed on or some sort of applicator was used. It just looked like it had landed there.
I have no further questions of Mr. Witucki. Thank you.
When Attorney Gravely had asked of your opinion of your peer review of analyst Treffinger's opinion about the source of that stain or what that stain was, you said that it was more based on your experience opposed to scientific certainty, correct? That was your answer?
I think that's a fair statement.
And is it a fair statement because that was never actually tested to be blood?
That's correct.
And in order for something to be scientifically certain in an analyst world, if you're going to say something is what it is, it's important to have the testing to back up that assertion, correct?
Correct.
And so in this case, there was no test that said that stain was blood.
That's correct.
You talked about your observing of the stain. You did not observe that stain in person, correct?
I did not.
And you weren't able to look at the stain under a microscope, correct?
Correct.
You were limited to the picture that was just shown on the screen.
That's correct.
And you'd agree with me that it is hard to determine or make an actual determination solely based on that photo to be able to characterize and make a complete determination about the stain pattern.
That's a fair statement. Lisa did magnify it for me, so I was able to observe the edges and the overall surface texture. But you're right, there are limitations to viewing a photograph.
Some of those limitations have to deal with the angle that the photo was taken at, things of that nature.
Yes.
I want to go back to the State's Exhibit 44. Is that still, did the state hand that to you? It was your report?
I did. Yeah, it should be.
Okay. So you had testified about some swab that you had extracted for testing, correct, as it relates to a pair of jeans?
Yep.
And you
Correct.
you had known that those jeans belonged to Mr. Anderson?
That's what I was told, yes.
And you were told that by whom?
I believe it was on the inventory sheet as to who they belong to.
And on the inventory sheet, it tells you, hey, this is really a very casual way of putting it, but hey, can you see if you can find, these are the interested parties, this is the suspect, this is the victim, can you see if their DNA is present anywhere?
Well, correct. I mean, I was told to examine the item, see if I could find any stains on the item, and if so, make comparisons to any known individual profiles to see if it matched.
Okay, so as far as Mr. Anderson's genes, if you could just turn to page 2 of 5 of Exhibit 44 of your report.
Okay.
So under item says cutting of left cuff area of jeans, item AU2, that whole portion.
Okay.
And that was you had talked about it at length on direct with the state, but that was the sample that had resulted in a 2-person mixture, correct?
Correct.
And so you did what's called an STR mix to determine if you could make a conclusion of the mixture.
Correct.
Can you explain what that is to the jury?
So in this situation, I found a mixture that was consistent with 2 individuals. Now, I ran the SDR mix computer program on that sample. And part of the procedure is if you have a profile developed from an item where it's likely that you know one of the contributors, then you need to tell the program that assume that this profile from this individual is present and tell me who the second person is in the profile. So that's basically what this profile did. And then when I compared the known individual profiles to this second contributor, each one of them came back as an exclusion that they could not explain as being the source of that second contributor.
And so one of those mix that you put in for this comparison and analysis was the DNA profile of Mr. Anderson and the DNA profile of Mr. Gutierrez, correct?
Correct.
And when you ran that test, the results came back, the likelihood ratio was 0.
Yes, and that means there's no, it's an exclusion, and the evidence is not explained by a mixture of those 2 individuals. So that person is excluded as being the second contributor.
And exclusion with a 0 likelihood ratio means it's absolutely impossible that none of that person's DNA was on that item.
That's correct.
No further questions for this witness.
No questions on those.
You may sit down, sir. Please don't talk about the case during the break. Are you folks comfortable? Now that you've been here 8 days, I should ask if they're comfortable. Please raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Ms. Remsburg, can you state your first and your last name, and please spell both your names for the record?
Catalina Remsburg, CASALYNAREMSBURG.
We want to turn your attention back to the time period of mid-May of 2020. Were you employed in May of 2020?
Yes.
And in general, what kind of job were you working?
I was an assistant kitchen manager at Quick Trip.
Okay. And were you living with anyone during that period of time, May of 2020?
My older sister, Christine.
Okay. And is her last name Remsburg as well?
Yes.
Okay. And how long had you been living with Christine Remsburg by the time period of May of 2020?
About 2 years at that time.
And in that capacity of knowing Christine Remsburg, is there anyone here in the courtroom you also came to know through her?
Zach.
Okay. Is that person that you've just named as Zach here in the courtroom?
Yes.
For purposes of the record, could you point out where that person is located and say what they're wearing today?
He's right there. He's wearing a gray tuxedo.
Indicating the accused.
Okay. And so I'm going to refer to him as the defendant.
Okay.
You'll know who I mean, correct?
Yes.
Okay. So, Ms. Remsburg, during the time period that you were living with, in May of 2020, how did you know the defendant? So, like, how was he connected to either you or your sister?
He was my sister's boyfriend.
And how long had they been boyfriend and girlfriend to your knowledge?
About a year.
Okay. And that was all a period of time that you also lived with your sister?
Yes.
And during that approximately a year, how many nights, if ever, would you estimate the defendant would spend at your home with Christine Remsburg?
About 4 or 5 nights a week.
And that was through that entire about a year?
Yes, about.
How often did Christine Remsburg go over to the defendant's home during that time period?
She almost never, only once.
Once in their entire relationship?
Yes, that I know of.
Okay. And at the period of time of May of 2020, now I'm directing you now to May 17th through 19th of 2020, right? Just before someone came and found you at Quick Trip.
Okay.
Did you know your sister to be driving a particular vehicle during that time?
Sometimes she would drive Zach's car, which is the black Audi.
Okay. And why was she driving that car, if you know?
She wrecked her old car.
When she wrecked her car, was she, to your knowledge, was she the regular driver of the Audi because her car was wrecked?
Yes, I think so.
Okay. And so what car did you observe the defendant driving during that period of time, so May of 2020?
He usually drove the gray van.
That would be the most common car you would see with him?
Yes.
And now I'm going to turn your attention to May 19th, 2020. Did you work a 2 to 10 shift on that particular evening, if you recall?
Yes.
And on the 19th of May of 2020, did some people come who interrupted your work shift?
Yes, it was 2 detectives.
Okay, and did they appear to be from the Kenosha Police Department? If you know?
Yes, I think so.
Okay, and were they asking you about what had occurred 2 nights earlier on May 17th, 2020?
They asked me if Zach was at the apartment that night, and I said no, he was not.
And you felt confident of that?
Yes.
Now, it had only been 2 nights earlier, right?
Yeah.
So your memory wasn't a problem?
Yeah, correct.
Okay. And do you know on that was a Sunday, so on that Sunday, May 17th, 2020, did you work a shift?
Yes.
So you worked from when to when, if you know?
I worked 2 to 10 that night.
Okay. And then where'd you go next?
I just went home right away.
All right, and when you got home, what, if anything, can you say about whether the defendant was present?
He was not.
And was anyone present?
My sister was.
And what do you recall about how your sister was acting or feeling about the fact that the defendant was not present?
She was a little upset because she was going to make dinner and he wasn't there. So.
All right. And at the time you saw her after 10, did she have any explanation for why the defendant was not present?
Objection calls for hearsay.
Is it being offered to prove the truth of the matter asserted?
Yes.
She's already testified. Ms. Remsburg has already testified. This is her simply indicating what her impression was.
Yeah.
It's cumulative.
Objections overruled.
Okay. So again, did it appear to you that that she knew, had she received any information or knowledge of why he wasn't there?
No, I don't think so.
Okay. What time did you go to bed that night?
Probably around midnight.
Other than you and Christine Remsburg and then the defendant 4 or 5 nights a week, was anyone else living in the residence at that time?
No.
If you know, during this time period of May of 2020, were there times when your sister and the defendant would leave and go elsewhere, go out someplace together?
Once in a blue moon they would.
Okay.
Yeah.
And if you recall, what vehicle would they commonly use? Again, if they used one vehicle commonly, if they both went out somewhere.
I think it was a black Audi.
Okay. I don't have anything else.
The state had asked you about, when your sister and Mr. Anderson were dating, if they would go out on dates, and you said maybe once in a while. Remember that question?
Yes.
It's true that the majority of the time that they'd be hanging out, they'd be in the house watching movies, things of that sort.
Yes.
No further questions.
Nothing on that.
You may step down.
Your Honor, state calls Marquand Washington to the stand. Yep.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please be seated.
Mr. Washington, can you state your first and your last name and spell your names for the record?
Marquand Washington, M-A-R-Q-U-A-N, Washington, W-A-S-H-I-N-G-T-O-N.
How old are you today?
31.
And where have you most regularly resided in your life, lived in your life?
Racine, Wisconsin.
Okay. Have you ever been convicted of a crime?
Yes.
How many times?
6.
And are you in custody right now for charges that are called federal charges?
Yes, sir.
And does that mean the U.S. government is prosecuting you?
Yes, sir.
So it's not the state of Wisconsin that's doing it?
No, sir.
And pursuant to that federal charge, in general, where are you being housed? Are you in a federal jail or prison, or are you in a state institution?
I'm in a state institution in KCDC, but it's mixed with federal as well.
Okay. And so KCDC is a institution or jail here in Kenosha?
Yes, sir.
Judge, could you ask the witness to talk right into the microphone? Can barely hear him.
Yeah, you got to speak up. Okay, can you do that?
Yes, sir.
Yeah, thank you, counsel. As part of your federal prosecution, have you entered into a plea agreement?
Yes, sir.
Okay, so I first want to talk about what your federal charge is. What do you understand you are charged with right now?
Conspiracy.
Okay, and is that to conspiracy to deliver drugs, illegal drugs?
Yes, sir.
And what are the drugs that you are charged with conspiracy to deliver?
Cocaine and marijuana.
And would it be accurate to say that the cocaine that you are charged with conspiracy to deliver is 30 plus kilos of cocaine?
Yes, sir.
Okay. And what quantity of marijuana are they saying that you were in a conspiracy to deliver?
I believe 600 pounds.
Okay. And so you've entered a plea in that case. Is it a plea of guilty?
Not guilty yet, but.
Okay. So what is your status right now in that case?
Witness's last word was but.
I thought he said not guilty yet.
Correct.
Oh, I thought
said
I
yet.
thought he said, yeah, you're right, that mic doesn't work.
Yeah. Okay. Should I go on?
Yeah, please.
Okay.
Sorry to interrupt.
So, and is it your plan to enter a plea on those charges?
Yes, sir.
Okay. And have you entered into a plea agreement with the government?
Yes, sir.
And is that a document or agreement you've signed?
Yes, sir.
And does it indicate you are going to plead guilty to some charges?
Yes, sir.
So did you do these offenses that they're charging you with then?
Not the amount, but yes, sir, I have.
Okay. So you're pleading guilty to the charges that we're talking about?
Yes, sir.
All right. Does the plea agreement, what does the plea agreement say about whether, if you know anything about other crimes, whether you should talk about it or testify or any of that? What do you understand your plea agreement to say about that kind of stuff?
The plea agreement basically said that if I was to enter into this plea agreement and sign it, I would have to be honest about anything that I had knowledge about.
Okay. And so you're supposed to be obligated to do that?
Yes, sir.
Okay. And is there a benefit that you believe you would receive if you provide information on different cases?
If I'm honest about everything, possibly yes.
So what do you understand could be your advantage? So like how could you be helped if you're honest about some other crimes?
What do you mean, like?
Well, like what advantage what's in it for you, I guess is what I'm saying.
Well, leniency on sentencing, I guess.
Okay.
So.
And do you know what that means? Like what number that means?
No.
Okay. Has anybody told you what the number is?
No.
And what is your understanding of what happens to you and your agreement if you are dishonest to a court or to authorities? What happens to you if you're dishonest?
I probably wouldn't get anything for it.
Okay. Are they able to hold that against you?
Yes.
So could you be worse off if you lie?
Probably so, yes.
Okay. And could you mess up your whole agreement?
Yes, sir.
So, and have you been warned about that? Have people told you, here's what might happen if you make something up or if you lie?
Yes, sir.
So you feel like you understand what the consequences are if you were to tell lies in a courtroom or to authorities about any matter? You think you understand what happens?
Yes, sir.
So how long have you been in a jail in Kenosha on these federal charges? Like when did you first get to Kenosha for jail on the federal charges?
I believe about 15 months ago.
You remember what month it was or not?
December, I think, of 2021.
Okay. So, and at some point during your time in the Kenosha jail system, did you come to be housed with a person who you found to be named Zachariah Anderson?
Yes, sir.
And what did you call that person? Like when you were speaking to them, what did you call them?
I called him Zach.
Zach. And were you, if you know, did you room with that individual personally? Like you were actually a roommate of that person's?
Yes, sir.
And which institution? So there's a downtown jail and then there's KCDC, right?
Yes, sir.
Have you been in both of them during this period of time of incarceration or just one?
I started off at downtown area for a week or so, and then I went to KCDC.
Okay. So is the place that you roomed with this person that you said his name Zachariah Anderson, was that downtown or was that out at KCDC?
It was at KCDC.
And when I say that you room with someone at KCDC, tell me what physically that means. Are there 5 or 10 roommates, or just, how many people are, when you say you room with somebody, how many people does that mean?
Just 2 people, me and another person, which was Zach.
Okay. So for a period of time, it was just you and Zach?
Correct.
Okay. And is the person you're identifying as Zach, is that person here in the courtroom today?
Yes, sir.
So could you point that person out today, and Mr. Washington, tell me what that person is wearing today?
Yes, sir.
Please point that person out.
Yes, sir. He is right there in the gray suit with the gray and blue tie.
I'd ask the record to reflect the identification of the defendant, Zachariah Anderson.
Pointing at the defendant.
Mr. Washington, did you room with the defendant from a time period from about December 22nd, 2021 through January 31st, 2022? Does that sound correct?
Yes, sir.
So if I calculate correctly, that's approximately 5 weeks, right?
Yes, sir.
Okay. And during that time, did you and the defendant come to know each other?
Yes, sir.
And did you have discussions with the defendant during that period of time?
Yes, sir, we did.
And at some point, did you discuss your case?
Yes, sir, I did.
And at some point, eventually, did the defendant discuss his case?
Yes, sir.
So when you discussed your case, who else was around when you were talking about the details of your case with the defendant?
Just me and Zach.
When the defendant discussed his case, who, if anyone, was around other than you and the defendant?
Just me and Zach.
What, if anything, can you say about during the period of time you were with the defendant, whether you observed any behavior about him having trust issues about people or being paranoid or worried about the government?
He had a lot of paranoia and different trust issues when we was in the cell.
Okay, you got to speak very clearly, okay?
Okay.
So, all right, so what sort of things did you see that caused you to think, okay, this guy is thinking the government is doing stuff?
Oh, when I was in the cell, he would, initially stated that it was a couple of times that he thought maybe that the government was putting informants in the cell with him, or maybe bugging the cell or recording things without his knowledge.
And did you ever see him do any searches?
Yes.
And what did he tell you, or what did he indicate to you he was searching for?
He was checking to see if there was any recording devices around or some type of camera or something in the vent, just looking.
And did he ever discover anything?
No.
And what, if anything, can you say about whether the defendant, what his opinion was of his own intelligence or about an ability to outsmart people?
Well, he thought he was pretty much smarter than everybody, pretty much.
And what sort of thing did you hear that caused you to believe that?
Just the things that he said about, like, eventually when he talked about his case, or how he would deny things but thought that he was going to beat the case, actually, and that you guys were trying to frame him and he was going to get out.
Who did he say was framing him? Do you remember?
He said the police framed him.
Did he say how they had framed him, what they had done?
No, he just said that they was planting evidence and trying to put something on him that he didn't do.
All right, so he indicated to you specifically that the police had planted evidence?
Correct.
Was that said to you once or more than once?
Said a few times.
Okay. And can you indicate, any ways that you and he helped each other out? In other words, anything that caused you and him to begin to trust each other for any reason?
Well, when I was in the cell, like I said, we became close. Sometimes, like, if I needed him, he would come through for me, and if he needed me, I would come through for him.
Give me an example of the kind of ways you meet.
Like, the first time ever was, because he usually don't share or do nothing or order much. He holds on to the stuff that he have. He had some food that I needed to cook with at the time, which was tuna, and I asked him, could I get the tuna, and I would order him, 4 back for the tuna, because he did it before with other people, and some people didn't come through on the end, and I showed him that I come through.
So, Your Honor, Mr. Washington is sort of soft-spoken and the words come out kind of quickly. Can we just ask the jury, can they understand him so far? I just want to be sure that they're able to understand him.
Sounds like it.
Okay, good. So, Mr. Washington, it sounds like you negotiated a loan kind of thing, right? You pay me now or I'll pay you later kind of a deal.
Sir.
Okay. Was there a point where, in discussing the defendant's case, that he talked about any involvement of his brothers?
Yes. He said that he couldn't have contact with his brothers because you guys basically try to say that they had something to do with whatever he had going on with his case, but he didn't.
And did he indicate to you, did his brothers have anything to do with any of this?
He said they didn't.
Okay. So how was he acting about that? Was he sad? Was he very calm about that? What was his reaction to the idea that
Judge,
hold on, let me finish. That his brothers would be involved?
Judge, objection leading, and he's been doing it repeatedly. I let it go, but definitely leading.
So I've directed him to a topic, and then I've asked what, if anything, was said about that. That's not leading.
And then gave 4 options.
Well,
and if I
no. I think it could be less leading.
Okay, so what, if any, reaction did the defendant have to the issue of his brothers being suggested as being involved in this incident?
Well, he was angry about it. He was mad, actually pissed off. I don't know if I could say that.
Okay.
But
and were you able to find out some personal details about the defendant's background?
Yes, I was.
Okay. So what, if anything, did you come to know about his family in terms of who he got along with, those kind of things?
I found out that, he had brothers. He had supposedly have a sister or something. I don't recall sister. I don't know if it's a sister or not. Him and his dad wasn't close growing up. He lived with him or something like that, but, they didn't have a always good relationship. He told me that they fought one time. He was tough on him and his brothers, stuff like that.
Did he say anything about anyone dying?
He mentioned something about somebody passing away, but I don't remember who it was.
And did he indicate whether that was a problem for him with his own family?
Not that I could recall. I just know that he said he was split up. He wasn't with his mom or his dad. I don't know how he got split up or what was the reason why he was split up.
Did he tell you in terms of sort of everyday jobs, not doing illegal stuff, but as terms of everyday jobs, what sort of professions he had worked in?
Yes, he told me that he was in did cabling and construction work like that.
Okay, the first one was cableman. Cableman.
Yeah.
Okay, and the other was construction.
Correct.
And then, did you have any topics that you felt like the two of you bonded over? You had some things in common.
Yes.
And what was that?
Illegal things.
Okay, so what?
Objection. I think we've revisited this before. I think I'd have to be heard outside the presence of the jury here.
What would the relevance of this particular answer be?
Okay, do you want me to? I would reveal a lot of details by saying it. I will if the court wants me to, but I want to be careful.
It's that time again. This shouldn't be long. Please don't talk about the case. All right.
So,
well, the objection was.
So the objection, Judge, was that, and I was concerned about this as I read the reports, not only from the interview that Mr. Washington had with Mr. Gravely, but from the debriefs, that that there was some discussion supposedly between the two, Mr. Anderson and Mr. Washington, about, you know, what the very things that we were worried about before, accusations of drug dealing, the other case he has. And so when he asked about like other, like regular jobs, I thought, okay, we're going to avoid that. I thought we were going to avoid it. But then the very next question was, his answer was about, like, what else did you discuss about, I don't know if it was about work or whatever, but it was, and I think he just said illegal things, or about what they bonded over. And so clearly that's where it's going, or, you know, maybe we can nip it in the bud here, but that's the reports from his interviews, in at least a portion of it, involve talking about Zach's other case, and, you know, going back and forth from California, that sort of thing.
Mr. Gravely.
yeah, so I do intend to bring these details up. So this is not something that I'm doing accidentally. So Mr. Washington has indicated in his debriefing to us in our discussions with him, and this is revealed in the reports, that the reason these two bonded, the reason that they felt they could confide in each other, was their shared discussions about the drug business that they had been involved in. So, you know, just like you might say as an inmate in the jail, I bonded over fishing, or as an inmate in the jail, I bonded because we went to the same high school. This is how these individuals bonded. I mean, this is the true facts that was described. And some of the details that Marquand Washington knows are things that are not in a criminal complaint. They're details which reveal that Marquand Washington had real conversations with the defendant. Not that he is just an individual who could come in here and be a mercenary and just describe some facts that he read in a newspaper article. And I just want to give you a couple examples of that. He said he caught a case going back and forth from California. But he's not worried because it's not that much. He's right. In the context of these sorts of cases, it's not as much marijuana as many cases are. And it is a case where he's caught, presumably coming from California or from the West Coast. So again, this is something Marquand Washington knows that he wouldn't know through any other source. The next one is that the police in this case raided his house, took a bunch of money from him, but just a little bit of weed. Again, in the context of these gentlemen, this is 2 pounds of weed, which is not a lot of weed in the context of what you've heard. But it is more than $47,000, so it's a lot of money. And so again, this is something that Marquand Washington knows because they've had common discussions about the drug trade and what they have each done within the drug trade. The jury has no other reason to presuppose that Marquand Washington would bond with the defendant. They have no other logical connection. They did not grow up in the same city. Et cetera, et cetera. And this is the actual answer offered by Marquand Washington when he was asked the question, how did you guys come to bond? He said, we bonded over our discussions of our various activities in the drug trade. And that is the answer he offered as to why he knows those kind of details. So again, Judge, this is, the jury has already heard and been permitted to hear that he was on bond on a matter in South Dakota. They've already been permitted to hear that there was a grow operation that had gone on at his home. So there are facts already in evidence in this case. This is not information that will be a shock to the jury or is that, but it has a very specific purpose to let them know Marquand Washington has some reason to know or have some reason to have these details at his disposal.
Judge, this is a pretty not very transparent attempt to backdoor some other acts. There was no motion about this, and just because they do a debrief with some informant that they want to call as a witness doesn't mean it's all admissible. Just because that's how they bonded, that doesn't make it admissible. That doesn't make it anything other than what it is, which is another act, which requires a motion before the court and a ruling by the court. And none of that was done. All of this stuff was widely available in the media. It's on the complaints. It's all public information. So, the fact that, even besides the fact that they need to fit it into another acts analysis, it's and it's not relevant. It's still not something that goes to prove what they're purporting it to prove, which was the bonding.
I want to indicate again that counsel's made an argument that this information is in the criminal complaint. I don't think there's any mention of the money in the criminal complaint or that marijuana was recovered in the complaint. Do you agree?
I'm working through all the
Yeah,
pages, but
and I'm not aware that the complaint has any details about the defendant's involvement in the drug trade. The only thing it says is that there is a conviction in South Dakota because, of course, it alleges him to be a repeater.
I said the news media and the complaints.
Again, I'm not aware of any specific coverage, and maybe you guys are aware of it, and I don't know it, but I'm not aware of any specific coverage about his drug activities that have occurred in the media.
Yeah, and I was referring to the Zaki County complaint also.
Okay.
It sounds to me like evidence which is generally inadmissible. Other crimes, wrongs, and acts.
I missed the last part. Apologize. You kind of, your voice, we lost your voice.
Everyone should be so lucky. It sounds to me like you want me to let in evidence which is typically barred by the rules because of the risk of the defendant being branded as generally a criminal personality or having a character trait of criminality. And in order to bolster the testimony that he committed a crime in this case, which is dissimilar entirely from the bolstering evidence. I have to say I understand the logic of your position. What I don't recall is any time this has ever been permitted, nor any time that I've read in a decision or a treatise that this would be a permitted use. Now I understand those have swollen a great deal in the last 50 years, the usage of these types of materials, but the general rule is still one of exclusion. From the fear.
So
Yeah, go ahead.
Yeah, so there's a warrant done in this case, which is part of this case. So it's not another act. There's a warrant done, right? Found in the warrant is 2 pounds of marijuana. Okay, substantial amount of marijuana for any kind of, for any kind of typical drug investigation. There are a number of items that certainly anybody involved in this case would identify as marijuana seeds. The daughter of the defendant provides information that while she is staying at the house, which are on visits, that the defendant is involved in the cultivating and manufacturing of, and she actually knows the specific number. She can say of 72 plants. The daughter knows more about the cultivation and production of marijuana as an interviewed 12-year-old than I do, and goes through detail about that in her discussion with law enforcement about her father, the defendant, and his conduct. The defendant, we've already said in this case, the defendant is on bond in South Dakota on an offense. So the jury already knows there's a warrant, drugs are found, they know that there's bags of material out there that were the soil from a marijuana grow. They know that they've heard already that there was a marijuana grow that had taken place at this residence. So these are facts that are already in the jury's sphere. And frankly, Judge, we're in a situation now where persons who are in the marijuana business often are doing that legally in many places. And so I can't remember what the vote was in Kenosha County for legalization, but it was significant. I want to say it was 60% plus in Kenosha County. And so I don't think we live in a world now where I have no evidence, by the way, so I'm not aware of any time that Marquand Washington would indicate that anything other than marijuana was involved in the defendant's dealing. So we're not talking about a guy who Marquand Washington will say was dealing fentanyl or was dealing even cocaine. So they're talking about quantity marijuana business, which is the way that these two first had their substantive discussions about, about what they have been up to in life. It is the icebreaker for these two individuals, Judge. You don't get to, you don't go right away to, hey, have you committed a murder? You have some discussions about what each of you have done to get you. That's the icebreaker. And frankly, marijuana is not held in such disdain now, or with such acrimony that I think that there's any realistic feeling that there's prejudicial effect for the defendant. I'm not ever going to argue, and I don't think anybody would ever argue, because the defendant has marijuana involvement, therefore he murdered, and this was a discussion we had earlier, Judge, on a different day, where the court asked me, are you, and the defense, are you saying that there's a connection here of the marijuana business to this offense? And we have said no. What we've said is that they opened the door by showing some bags and asking, cops, why didn't you search this? And those kind of things. But in this case, we're not talking about doors being open, but we are talking about evidence that they already have, that the jury has already heard. This is just supplemental evidence to this, and it is the direct, honest, real, and truthful answer that it's the icebreaker.
Don't use the word honest.
I apologize.
That's not for me to decide.
Okay. It is and so I shouldn't use truthful either. It is the offered answer by Marquand Washington about why we were able to have any discussions about things.
But the problem is, we have to realize that the rules generally exclude this propensity evidence. It is clearly barred in order to prove that the defendant has got a character trait or
totally agree.
Propensity to commit any crime.
Totally agree.
And there are a number of exceptions. If you go to the textbooks, Professor McCormick said it has to, for admission, it has to bear the signature of the accused in identity cases. It has to be the type of crime that is actually his signature. We all watched Home Alone at Christmas time again, and that I don't remember their names, but the guy who's not so smart always wants to leave the water running. It's his signature at the crime scene. And that's what McCormick talked about. But it has utility. And the black and white rabbit case, the Woody case, that is beautiful example. This deviant approaches children on different occasions and says, help me find this black and white rabbit. And that's how he gets contact with the children. It's his signature. We're not using it for that purpose here. What you're asking me is to admit this, and I'm not saying you're illogical, but you admit it to show the trust that these two have with one another, that they've bonded. So the criminality that they're discussing, the witness more believable.
So the court agrees it's relevant
So
because
if
bonding
I
would
could,
be relevant.
if I could be heard, because
Well, yeah, all right.
yeah, thank you. So there was a limited inquiry earlier over objection, but now what's clear is not only are you correct, this is another act, as we've discussed, and clearly barred, but now it's also clear that this isn't some supplemental, to use the state's term, this isn't some supplemental offering. This is like turning into the main aspect of their case. And he keeps talking about how there's all this marijuana at the house. Well, we don't know that. None of it's been tested. And it's a separate case.
But I do agree with his observation that people are feel very differently about marijuana, whether it is or isn't. The governor has proposed to make it legal. I was just reading the budget portion yesterday. It's supposedly legal in the state of Illinois. The president has proposed that it be legal. And public attitudes have very clearly changed so that what was once viewed as a very, very serious matter is not looked upon that way. Even people who oppose its legalization will get on TV and joke about it and about their own experiences with it.
And
so it's not what it once was.
And I think that's true, but that still doesn't get us past Sullivan or Witte or any other, or the statute itself in terms of its admissibility. So I think the court is on point with the fact that this is, in essence, it's, no matter how the state wants to couch it, it's still character evidence, and it's still there for, they're trying to get it in sideways for an improper purpose, and it needs to be excluded. And they need to be on notice that they can't do this with Sadie, and they can't do this with his daughter, because they're full, as he just said, they fully intend to do that.
Yeah, we do intend to do it through Olivia. I don't think Sadie has anything to do with this, but Olivia is going to indicate that all of these things occur, and if Olivia is lying about her father's activities in terms of all the rest of this, how odd that she would be telling the truth about the marijuana that was grown there, that evidence was discovered of. That's not a distinct another act. That is conduct going on when this case occurs. If we were in the same county, Judge, it would be in the same complaint. It's just that it happens to be in it happens to be in a different county, that it's not in the complaint. So that's not a distinct behavior that's different, and it's simply something that can't be charged here because we don't have venue on that. And in fact, it is a charged case, I guess, in Ozaukee County, right? But I don't think it is any distinct other act, Judge. It is these two indicating, here's how I do it, here's how I do it. We're not saying, and then he told me in January of 21 he did this, and then he told me of this. So it's not distinct sort of specific acts or specific items.
Why not? They're acts.
Well,
He's talking about
it's generic.
Information.
It's how I do it. It's how I do it. Kind of. That's the sort of information.
But there are other crimes, wrongs, and acts. I mean, it's even if it weren't a crime, it would be an act. It's character evidence, and the general rule is exclusion, except for specific aspects which are admissible for legitimate purposes. And what's getting me, and this is what I was trying to get at before, in all of the encounters I've had with this type of evidence, which is frequent, I've had it argued it's proof of motive, it's proof of identity, it's proof of modus operandi, it's proof of this, that, and the other thing. It's proof. It even became, after many years of judicial resistance, it's become proof of veracity. Now you're offering it to me as proof that this is a believable witness, that he was bragging about his criminal behavior with the defendant who was bragging about his.
It does. It is used for the purpose of bolstering the credibility of this reporting witness, which is one of the purposes Whitty is permitted for. To bolster credibility.
It bolsters his credibility?
To bolster the credibility of a reporting witness, yes. So, for instance, in sexual assault cases, Judge, you're allowed to bolster the credibility of a reporting witness. So, I guess what I'm going to ask the court to do is let me, as I did last night, try to dazzle you with a case which the court will strongly consider in the morning. So I will do the research, and I'll try to bring the court, because there's a body of law under Whitty, under 90404, which allows for a valid purpose of other acts evidence to bolster the credibility of a reporting witness.
So
I'd
Judge,
like to be able to do that.
so he's now pivoting very quickly under your fire that now it's not just the bonding. Now it's part of Whitty. Now it's part of Sullivan. Now it's proper under the other acts, even though it's not an other act. So he's trying to, I guess, run parallel paths here. But the bottom line is that if he was, okay, we all know it's another act. And that requires a pretrial motion, not something on the fly during trial. And even if we just ignore his comments about how it's not another act, he doesn't get to just come up with a case and try and argue it. And this is not some incidental thing to his case. He's made it clear. He wants to do it through Mr. Washington. He wants to do it through Olivia. He's already done it to a lesser extent in prior witnesses. So he wants to turn this into a drug case and to smear Mr. Anderson's character, pure and simple. And that is precisely what 90404 is about, and to prevent.
So, Judge, counsel, has indicated that I think has indicated there's something untoward for me to make an argument about what I believe that the presentation of the evidence is, and then in response to the court, when the court suggests comments from the bench, you're the guy wearing the robe, and you say things like, well, I consider other acts, etc. It feels like it's not dishonest for the prosecution to then say, well then, Judge, I'd like to be able to present you a Whitty case because there's body of law. I don't think it's a dishonest change of argument to listen closely to what the court says, to understand what the basic parameters and guidelines are of the court's current thinking, and to try to respond to that. And I wonder why we would need to have the quality of our debate here be that those kind of things appear to be dishonest. I've cited nothing that's wrong.
I don't want to get into these attributions about. It's pretty clear that you people have not been on the same track with respect to how to handle the case, and I don't care.
Right.
But what is this case that's going to dazzle me? What's it going to tell me?
While they're looking, that's the reason we have pretrial motions, so we can rationally do research, present it to the court, have a hearing, and not something where we're just changing our theory mid-sentence and then try and find a case quick.
So the counsel said that this case was all about the drug evidence, and of course this case is all about the DNA evidence. So Judge, we suggest to the court that I believe I'm aware that there are cases as I have purported. I don't need to repeat it. There is also a possibility that what's called panorama evidence, in other words, setting the circumstances. Again, I've already outlined why I think this meets the credibility, would also be a valid, witty place. So, again, Judge, I'd like an opportunity to convince you by showing you a case or two that puts us in that position before we go any farther and not have this allowed. I think it's important evidence in this respect. I don't know why a jury would believe guys who spent 5 weeks together have bonded enough for a murder to be confessed to them unless there's something that is a middle ground. I don't need to repeat that again in any detail. I think the court has heard me and understands that there's relevance in that respect. And so now I just want to see if I can find a case, now that I understand that the court feels its other acts, which was not my first thought process.
Well, there was a scheduling order in this case to file these motions. Enough said, right?
Well,
and for what it's worth, I've litigated other acts motions for decades, and I'm very positive that the first prong of the proper purpose has never, ever, ever included bolstering a witness. Ever.
oh, I think it's admissible since maybe the early 90s. It's admissible for veracity, to bolster veracity.
Yeah.
Well,
I mean, counsel's indication that he doesn't believe any of these cases exist is exactly why we should talk about this, because his argument is being made indicating he doesn't think there's a body of case law about this. I believe there is, and the court has just, I think, confirmed that. So,
well, no, that didn't say that at all. What I said was that this should have been brought pre-trial. It's clearly a huge part of his case, and he's trying to turn a murder case into a drug case. But he's actually trying to win a murder case by turning it, by smearing it with the veneer of a drug case.
again,
that much is clear. He's not trying to bolster this witness's testimony. He's trying to smear Mr. Anderson's reputation.
These arguments with this rhetoric, Judge, should be admonished by the court.
I'm more busy right now. Well, the purposes for which, and I do think it's other acts evidence. Otherwise, it would be irrelevant. motive, opportunity, intent, preparation, or plan. Oh, these are the ones that are both in the statute and then in instruction 275, which is suggestive of other uses. Knowledge, identity, absence of mistake or accident, context or background. And then it says identify other issue. So there are, as we know, there are other issues. And then there was case law, I think, in the late 80s, early 90s, that recognized it could be used to bolster the witness's credibility. But I didn't think that the language of any case was sweeping enough to extend to allowing witness to testify as to braggadocio that he and the defendant exchanged to prove the accuracy of unlawful behavior of the defendant, for which he's not on trial. It's not to be considered to conclude that the defendant has a certain character or a certain character trait, and that he acted in conformity with that trait or character with respect to the offense charged. So that's
delivery of marijuana does not equal murder. I mean, no,
correctamundo.
So I'm not asserting it for the purpose of indicating it makes it more likely he committed.
So it becomes relevant because during the course of the discussions, the defendant made some admissions, you claim, with respect to the crime in chief in this case. And you could introduce those stripped of the other crimes, wrongs, and acts evidence. But you fear he's less believable then.
Right, and I'm looking to bolster his credibility. That's exactly it. Of course,
And you have
the issue.
and you have some, what was the word you used? The adjective?
Dazzling.
Dazzling case law to support.
Well, and it was, of course, a word that was based on your reaction to my State v. Weed submission first thing this morning. So I'm still suffering the wounds from that experience and asking the court to let me repeat it in the morning.
So, Judge, if I could, even if we get to that far, he can't bolster. I mean, even if those cases exist and it's more sweeping than maybe we recall or whatever, you can't bolster until it's been attacked of a witness.
That is the general rule.
Yes. So clearly
Maybe that's by the case.
it's his witness right now.
I will be shocked if the defense concedes that Mr. Washington is truthful and is telling no lies, and so I am anticipating, I think with good reason, that Mr. Washington will be challenged aggressively and his honesty will be placed into question. I don't think I misread any signs here, and I think the court can, in anticipating the evidence, understand that. Just as we would anticipate anyone in this circumstance, Mr. Washington's circumstance, would be attacked when he reports that the defendant has admitted a crime.
I don't buy into your basic precept, which is the fact that these two jailmates, with nothing better to do than to talk about their past exploits, are bragging about their drug crimes, and that somehow makes them more believable. This is supposed to be evidence which is supportive of the state's case without painting the defendant as a bad actor. And it appears to me it would have the purpose, even though I agree it's less serious than it was once viewed. It accomplishes the purpose of painting the defendant as a bad actor. It also no, it doesn't either. But but at the same time, it's what is offered as the support, as the bolstering, is someone bragging about his criminal acts. Now, that's actually not why you're offering. You're offering it to they're relaxing their safeguards, and but boy, the rule was created for a reason, and we can stop now. It's okay with me.
Well,
and you can bring in cases in the morning, and of course, I'm.
From a variety of sources, I am receiving cases, so I feel confident I'll be able to bring something to the court. I have a number of persons who are interested in being of assistance on this issue. So I'm asking the court to break now before the court makes a ruling on this. And obviously we're not going to finish this witness today anyway. The court was going to finish at 4:30. I'm asking the court to let us break now, and we'll revisit this with whatever we can find.
For whatever it's worth, I'd like to continue.
Well,
with a granting our objection and prohibiting them from going forward with this theory.
I want to do it right, and I want to do it right, and this is why I do my thinking out loud and have these discussions, because people get my mind changed. I think I've changed my mind already in this case once or twice. So maybe he will dazzle me with some case, or maybe you'll bring some blockbuster here. I don't know, but it's pretty clear what my present feeling is. We can wait till tomorrow.
Judge, the defense would request, similar to how when the state objected during my opening statement and wanted to brief the issue, we had till 9 p.m. to provide something to the other party. Yeah. I'd ask that if the state's going to be presenting anything to this court in the morning on this issue, that similar courtesy be extended and that they provide that information to the defense by 9 p.m. this evening.
What do you think about that?
Well, I'm not able to comply with that because I teach at Parkside tonight, and so I have obligations from 5:40 to 8:45 tonight. But I do volunteer to place. I'll suggest any cases briefly as soon as I can this evening, and then or first thing in the morning if I need to do that. That's my request.
Judge, they have a whole office. There's another prosecutor sitting right next to them. I think they can get that done, especially since it's their burden and they're the ones that are wanting to, brief this and interrupt it.
While I do understand that you, like everybody else, like to sleep, I happen to be going to a meeting, and where I won't have to be dealing with this. I think there's only one other lawyer in the group, so I'll get some relief. And I'll be in that meeting until about 8. So, and I wouldn't reach anything that got submitted until 10 at the earliest. So let's make it 10:30. And
Could we make it 9:30? I go to bed early.
read it in the morning.
Huh?
Read it in the morning.
Judge, we just want to be, sorry, Attorney Mueller speaking. We just want to be prepared. You know, they've said that this case exists. We surely are capable attorneys that can do our own legal research on the issue. But if they're going to be presenting a very specific, nuanced issue, and we don't get that case law until very late hours after we've all gone to bed or early morning, we want to be able to make sure that we have a legitimate argument based in authority to this court.
And the bottom line is that I'm well. First off, when I graduated and came into trying cases, we were still working on the ambush system, and frankly, I thought it was more fun than now. But I understand it had many shortcomings. The fact that the fact that something comes in at 10 at night, give you some time. It's not like we're exploring some expansive area of the law. We're in a very, there's a lot of cases on it. There are more cases on this than anything else. There always are. And the prosecutors have been pushing this further and further away from the original rule for a long time. So there's a lot of law on it, but this is a first for me, and yeah, that's a really good idea. Ask them to come in. Are they just in the back room?
Yes.
And then could Mr. Washington then leave as soon as they have been allowed to leave? Mr.
Indeed.
Washington's on the stand.
In fact, he can leave.
Could he leave now?
Well, I don't want him to bump into them.
Which way are you taking him, this way or that way?
Bring the jurors in through here, have him exit through there. You're done for the day, sir. Thank you.
Can you?
I'll see you in the morning.
So there's a keep separate so that you know. And can you have him brought at 9 o'clock tomorrow? Sure. Thanks.
I'm actually going to invite the jurors back at 9:30 because we're going to be working tomorrow for. We'll be locked out in a half an hour. All right. Huh? Oh, I never get finished. I didn't finish that. You're such a nice jury. You really are, and that's sincere. This is what's happening in this particular case is I've been here 40 years, and I've never had one like this. And I'm not blaming anybody. It's the way it is, and you people have been wonderful about it. I can tell you stories. So thank you for that. And we're moving ahead. And I'm going to actually ask you to come in at 9:30 tomorrow morning because I know we're going to be going for a while here this afternoon, and we're going to not have it resolved. This particular subject we're talking about, I talked about hearsay and how much of the book it occupied. This particular area of the law we're talking about now is the most litigated area in the law. If you look at the appeals over the years in the various courts, this is far and away the most litigated. So there's a lot of legal work that is involved in this. So give us an extra half an hour tomorrow morning. I recommend an extra half an hour of sleep, but whatever's practical. And I know we're using your time, but we're getting there. Please report at 9:30. Forgive me, 9:30. There were 11:30. There we go. Yeah, 9:30, and I'm going to make every effort to get you down here right away, and get back onto this. Please don't read, watch, or listen to any account of the trial. Discuss the case with anyone, even members of your household or other jurors. Any questions, anybody? Okay, thank you very much. Now, well, where did I leave it at? By what time tonight? 10? 10 o'clock.
I thought you said 10:30, but
You did at one point say 10:30, but you might have changed it. I don't.
You know me. That's.
I think you changed it to 9. Maybe I misheard. I don't know.
All right.
I was too busy having names called to me. I missed what time.
I will. I'll make a Solomon-esque decision and say 9:15.
9:50.
You said 10 before.
Oh, I did.
That was what you just said.
We're never getting out of here.
9. All right. 10 o'clock. 10 o'clock.
Might just be messing with us.
Judge, can you confirm for us that we are closing testimony tomorrow at 2:30 p.m.? Is that what you said earlier?
We are. We're stopping at what I don't know about where the testimony will be, but we are going to stop tomorrow at 2:30. 2:30, did I say?
I don't know.
You said you had to leave for an appointment at 2.
2:30. Okay. 2:30, and I apologize. This was not foreseen until a couple of days ago. And then I can come back at 4 and pick up. I'm not encouraging that because there is a judge's meeting with some issues that I would like to be there for. Although I'm sure Judge Gabrielle would do a wonderful job, even if I'm not there. Maybe. But
I don't need to know the details.
but we can go at 4 o'clock if we have to.
Is it an appointment where it's possible that there be a wait as well without telling us the details? So is it possible that you might not make it back
I
to
would not
4:15?
expect a lengthy
Okay.
wait.
My only concern is obviously this jury has gone in, out, waited, in, out.
Yep.
That for them to then wait around for an hour and a half, come back to then leave again.
Yeah, that's a good point.
I just want to agree with the defense on something, so I'm going to join it.
Thanks, Mike.
Fair enough. So we will.
I
we'll-
disagree.
We'll
Sorry
wrap
about
it.
it.
We'll wrap it up at 2:30 tomorrow.
You remember the good old days of the stipulation? You remember those days?
Oh, yeah.
That was a while ago.
But I